Wonderful. Okay.
Amy, are you ready for the virtual introduction?
Just about. I have one more to let in here, it looks like.
Thank you. Just to let people in individually.
Mute. Okay. Good morning, everyone. This is your virtual introduction for this meeting. All participants attending the meeting virtually are asked to keep their microphones on mute throughout the meeting. Commissioners, division staff, respondents, and attorneys participating by camera should remember to unmute themselves before speaking. All participants should state their name before speaking to ensure a clear and accurate record. Be patient when waiting for a participant to respond, allowing time for them to unmute their microphones or in case there is a delay with the audio. Participants should speak one at a time to ensure a clear record on the recording and for the purpose of preparing meeting minutes. Members of the public will be allowed to participate during the agenda items regarding public comments at the beginning of the commission meeting and before the meeting ends. Anyone participating by phone who would like to provide public comment should press *5 to raise their hand and be recognized by hosting staff, or press *6 to unmute and state their name. Anyone attending by video can click the raise hand emoji to be recognized by hosting staff or unmute themselves and state their name. If anyone has questions, issues, or concerns during the meeting, please email the Commission Coordinator, Maria Gallo. Her contact information is listed on the meeting agenda. The agenda and all supporting documents can be found on the division's website. If the meeting goes into closed session, all members of the public and division staff not involved with the agenda item will be placed in the virtual lobby. After closed session has ended, participants placed in the virtual lobby will be brought back into the meeting to hear and/or view the commission make a decision. To receive CE credit, your camera must remain on throughout the meeting, and you must give the meeting your full attention. Once the meeting adjourns, CE certificates will be emailed within 5 business days. If you have questions, please contact the division's CIC Education section. Thank you.
Okay, Chair. Okay, good morning, everybody. We'd like to call to order the March 10th, 2026 meeting of the Nevada Commission for Common Interest Communities and Condo Hotels to order. Let's move forward with introduction of commissioners in attendance. We'll establish our quorum and then we will stand for the Pledge of Allegiance.
Morning, Sarah Gilliam, homeowner member.
Kyle Pivots, developer member.
June Haydarian, manager member.
Bob Sweeten, attorney member.
Patricia Morse-Jarman, homeowner member.
So we are reflecting 2 commissioners absent, Ms. Lightheart and Ms. Tomaso. Okay, let's stand for the pledge, please. We do have a quorum. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, everyone. And now we'll move to introduction of division staff in attendance.
Morning, Commissioners, Madam Chair, President Rod Chandra, Administrator for the Real Estate Division. We've got Deputy Administrator Charvez Foger, Ombudsman Sonia Merriweather is here, also Chief Terry Wheaton. We've got Crystal Keegan, Senior Deputy Attorney for the division. And up north, we've got Robert Toll, Investigator Toll. And from the AG's office, we've got Phil and Steve. Bill. Sorry. Bill. Bill from the AG's office and Commission Counsel, Rosalie Book. Thank you.
Thank you. Okay, we'll move on to the next item, number 2 on the agenda, which is public comment. So members of the public are encouraged to address the commission regarding any matter. However, no action may be taken on a matter that is not listed on the agenda. Comments may not be made regarding matters that are or may become the subject of a formal complaint before the commission. Comment may not be limited based on viewpoint. Individuals who desire to submit written testimony should submit it to the commission coordinator. If you are participating by phone and wish to provide public comment, press *5 to raise your hand. Hosting staff will recognize you when it is your turn to speak. You may also press *6 to unmute yourself and state your name. If you are attending by video, click on the raise hand emoji to indicate that you would like to give public comment. Hosting staff will recognize you, or you can unmute yourself and state your name. Public comment may be limited to 3 minutes per person at the discretion of the chairperson. So do we have any public comment here in the room? Yes. Okay.
Morning, my name is Mike Kozar, homeowners. Been involved with before you now for many years, so hopefully all of you are familiar with me. I'll be brief because I know you've got a big agenda today, and the reason that you do is because of the workshop. And I think that is probably by far the most important thing this commission can do is the rulemaking piece that the legislators have very uniquely, by the way, I will point out to you, allocated. No other state that I'm aware of allows a commission to get involved in this level of rulemaking. Normally, it's just the agency itself. There's a reason why that's the case here in Nevada, and I appreciate you all giving it the proper manner. My point today is that what's on the agenda for the workshop, though, is controlled by the division and should be coming from this commission. Okay. This commission, I've given you a list that I provided this morning. Hopefully you've had a chance to scroll through it of the number of items that people call me, talk to me all the time about, geez, we're confused. We don't understand this. Why isn't this clear? And by your own admission, by own thing, if you look at it, you'll see that there's a number of these issues that have a lot of ambiguity associated with them that never come up before the commission for addressing. Like, personally, I believe the confidentiality that's being used by the division is extended. It then blocks all visibility into what's going on. And other agencies have worked around confidentiality by using redaction and providing reports as a result of investigations, but they're redacted. And so confidentially is retained. You got things like secret board meetings, workshops. Those have been occurring all the time, yet we don't have a definition on workshop because we don't have a definition of meeting. Same thing goes with virtual only. My association, by the way, has not had a single meeting, and it's got almost 9,000 people in it, has not had a single meeting of the board since COVID, where they've met physically, where homeowners can actually show up and say, hey, what's going on here? We don't like what's happening. Meet them, talk to them. It's all virtual. There's got to be some limits here. My sub-association votes by email on major contract determinations. And this is coming from council. Council is saying, from what I can tell, that's acceptable. I'd ask this commission to sit back, take a look at the list and go, gee, why aren't we talking about some of the other, and make it clear to the homeowners out there exactly what these laws are saying, okay? Make the rules so that the homeowners can participate correctly. Look forward to commenting further when we get into the actual workshop. Thank you very much for your time.
Thank you. Any other public comment in the room? Okay, we'll go up to Carson. Oh, okay, come on forward.
Hi, I'm Fred Blaskovich. I live at Desert Bloom HOA, and I'm having trouble getting books and records on the management company. Going on 3 years now. I request quite a bit, really, but just get like last year, I got minutes from two board meetings. That's all they provided. I've asked for about everything that you could get according to what I read in our governing documents and also the NRS. So my question is, does this commission do anything to work with community managers when they refuse to provide books and records?
Not sure we can. I mean, the public comment period.
Or is it okay for a community manager not to provide books and records to a homeowner?
Sure, Ashley would like to, but yes, you're permitted to respond, to discuss. You just can't take action or start deliberating intently, but I think
Did you have a comment?
complaints related to it might be directed to the ombudsman.
Yes.
Sure, that's for the record, Deputy Administrator for the division. Yes, we have a process and we have our chief here today. If you want to talk to him offline.
No, I want to talk right now.
Okay, so we have a process that you have to do. The commission won't have anything to do with unless your case comes to the commission. So you would have to talk to our office first and to see if we can assist you.
I've been through that process
Okay,
with a attorney hearing,
okay,
and the attorney that you guys used said it's okay not to provide the books and records that I requested, and the $25 fine.
Okay.
That's what.
Okay.
And then this went on for a year. They provided nothing. He said that there was no fine amount. He did not fine the HOA or the management company. So it seems to me that it's perfectly okay for a management company not to provide books and records to someone that asks for them, unless I've got that all wrong.
you're correct. You're wrong.
I'm wrong? I am not wrong. Then why does it happen?
Thing is, our attorney is sitting right next to you. So
Pardon me?
our attorney is.
I don't,
I'm gonna.
so what if
I'm gonna let us go on with the
your attorneys don't follow
We-
the
we can-
law?
We're more than happy to speak with you on this offline, if you like. We're not going to argue here in this
But I think it needs to be talked about now,
Okay.
because I read in the papers all the time,
It's,
and people are
it's
asking for books and
difficult for
records, and they
folks
don't
to-
get books and records.
it's difficult to respond without.
Why
knowing-
that's a simple
Well,
question.
Sir, I'm trying to help you here. Without knowing the details of your specific situation, it is difficult for this commission and
Just
anyone
drop it.
present. It's really not.
I've asked for contracts,
Okay, and I
financials,
understand that.
the
So you should
exact
receive
words
those
listed
things.
in our governing documents and the NRS, the exact words.
So
And those are not provided.
So there's.
And they
a
have no
mechanism-
problem not providing it.
So there is a mechanism to receive that. You do need
I
to
have been
contact the
through it.
ombudsman's office.
June?
Again, we don't understand all of the background
my
and history for
point
us
is,
to be able to.
Why can't you help homeowners get books and records that are supposed to be provided? Isn't that part of what you
the
do?
process to do it is going through the complaint process.
I have done that, ma'am,
The commission.
and I did not get books and records.
On a contested case through that. If they were to take some action.
I don't have a case right now.
Overturned by the
I
courts.
don't have a case
So the
right now.
commission does not have power to address individual complaints coming in on public comment. It would violate the law if the commission were to do that
This has
right
been
now.
going on 3 years. Now,
So this is.
I've
not-
lived in the
This right
community for 7 years. And always before, the management companies provided everything. Everything.
So if.
But
you would
now
like to work
in
with
fact,
the commission, you can't.
Tanya
This-
Gale
this isn't the
used to
time and
be
place for this right
on board, and now she is our Epic Management is our community manager. She provides virtually nothing. I asked for nothing.
This is public comment. The commission's heard your comments. There is a time limit. We've hit that. If you would like to work behind the scenes with division more on this or file a complaint with the.
As
ombudsman
a
office, they can
commission
look into it.
counsel,
There
can you
is-
encourage the board, honor
I
homeowners
encourage them
request for
to
books and
follow the
records?
law.
You do that?
They need to do that right now, which would be not taking action or deliberating on a matter during.
I'm
public
just
comment.
asking, what is your,
So that is why at this point,
so you don't want to talk about it? You don't want to answer any questions? It's
we
just
cannot,
like,
as was said in the
ma'am,
initial public
you are not
comment
a,
statement,
you're not a member.
I'm
You are not a
trying to
member of
comment.
this committee.
Yeah.
So this is just not the appropriate venue for this to be heard, sir. Thank you. Okay, any other public comments in this room before we go up to Carson City? Okay, Carson City. Any
This is
public,
Investigator Tom. There's no public comment out here in Carson City.
okay, thank you. Any public comment online?
Is there anyone interested in providing public comment at this time? You can press, you can click the raise hand emoji. I do have, hold on. Byron, if you would unmute yourself. Oh. And then I remuted you. There you go. Go ahead.
Throughout the workshop, will there be additional time to speak about the specific issues such as the reserve study changes, or is this the only time to do that?
Yes, there is. There is a public comment portion of the workshop.
Okay, I'll just hold my comments for then.
Okay, thank you. I do not recognize anyone else with a raised hand.
Okay, thank you. So with that being said, we'll go ahead and close the public comment portion of the beginning of the agenda. And we will go to item 3, which is the regulation workshop for proposed changes to NAC 116 and NAC 116A. And I will turn that over to Ms. Sherry Spates.
Good morning. Okay. So good morning, everyone. My name is Sherry Spates. I'm the Administration Section Manager here for the Nevada Real Estate Division. This is the time and place set to receive comments from all interested persons regarding the adoption of regulations that pertain to Chapter 116 and 116A of the Nevada Administrative Code as posted by notice of this workshop on February 9th, 2026. Today is Tuesday, March 10th, and the time is 9:19 a.m. This hearing is being conducted in the Nevada Business Center located at 3300 West Sahara Avenue, the 4th floor in the Nevada Room in Las Vegas, Nevada 89102. We are also video conferencing to the Nevada Division of Insurance located at 1818 College Parkway, Suite 103 in Carson City, 89706. The meeting is also being facilitated virtually through the Teams program. In attendance today, members of the commission are Chairwoman Haydarian, Commissioners Gilliam, Morse Jarman, Sweeten, and Tibbetts. And Commission Counsel is Rosalie Bordelot. At this time, I'd like to ask everyone to mute their electronic devices. There are copies of the proposed regulations, small business impact statement, and surveys available in both physical locations in Carson City and Las Vegas. And the documentation is also available online on our website. The flow for today, the proposed regulations will be read as numbered. They're read, each section is read into the record. After each section is read, we will pause to allow for public comment virtually in Las Vegas and in Carson City. And then we will have, and actually I should say, we will have public comment prior to the start of the workshop. Then I will read each section. There will be time after each section is read to allow for public comment. We ask members of the public to, if at all possible, save your comment for that section. If not, you will have time at the close of the public portion of the workshop to provide public comment as well. Okay, thank you. And then after the public portion of the workshop is closed, then we will allow for that time for the commissioners to then open up for deliberation and discussion on the workshop items. Okay?
Thank you, Mr. Bates. So Commissioners, Senior Deputy Attorney Crystal Keegan for the division. Before we start, I just wanted to assure you of your authority to conduct workshops. It's under our enabling statutes under 116 to provide the commission with the power to make the rules and procedural mandates of the Administrative Procedures Act. That's under NRS 233B, which dictates how that power must be exercised. So regardless of whether specific procedural regulations for the workshops have been formalized yet, the workshop proceeds according to those mandates, NRS 233B.061, and it's executed pursuant to open meeting law, NRS 241.020. And just to lay them out, NRS 116.615, NRS 116A.200, that expressly grants the commission the authority to adopt regulations. NRS 116.610 provides the commission with its general powers to do all things, quote, necessary and convenient, end quote, to administer the chapter. And lastly, NRS 233B.040 provides the agency the authority to adopt. Thank you.
Thank you.
Commissioner Darian, do you want to call for general public comment for the workshop and then we'll start reading? If someone has general public comment about the regulations, might be a good time to.
Okay. Is there any public comment in the room regarding the proposed changes to the regulations? Just general public comment. There is opportunity after each section to make additional comments. Okay. Any general public comment in Carson City?
There are no members of the public out here in Carson City.
Okay, thank you. Any general public comment regarding the workshop items online or virtual?
Is there anyone interested in providing general public comments on the workshop at this time? No, I don't recognize anybody interested in public comment at this point.
Okay, thank you. So we'll go ahead and close that portion.
Wonderful. So we will get started. Start with section 1, which is just at the bottom of page 3. So section 1 reads chapter 116 of NAC is hereby amended by adding thereto the provisions set forth as sections 2 to 14 inclusive of this regulation. Section 2, number 1, a violation of a provision of the governing documents of an association poses an imminent threat of causing a substantial adverse effect on the health, safety, or welfare of the unit's owners or residents of the common interest community if the violation involves conduct that includes, without limitation, a failure to exercise reasonable care that directly and immediately endangers a unit's owner, a resident of the common interest community, or an invitee of a unit's owner or a tenant. B, intentional misconduct that directly and immediately endangers a unit's owner, a resident of the common interest community, or an invitee of a unit's owner or a tenant. C, a public nuisance as defined in NRS 202.450, or D, actionable misconduct under state penal codes, including but not limited to, number 1, willful and malicious conduct intended to harass, intimidate, or stalk, as defined by harassment and stalking, NRS 200.571. Is that a sequence? That's a good question. I don't know how to pronounce that. Number 2, violent or threatening behavior as defined by assault, battery, and NRS 200.471.
I'd say it's sick.
It's sick. Thank you.
Phonetically.
Thank you. It's sick.
Second.
I'd say the same.
Sorry, everybody. Number 3, willful malicious destruction or damage of real personal property as defined in malicious mischief, NRS 206.010, 206.015, 206.040, and 206.310. Back to subsection E, violates provisions of housing or health codes concerning health, safety, sanitation, or fitness for habitation. Number 2, a violation does not pose an imminent threat of causing a substantial adverse effect on the health, safety, or welfare of the unit's owners or residents of the common interest community if the sole basis for imposing the violation is conduct that A, uses foul, profane, or abusive language, B, voices opposition to or support for any matter that affects the common interest community, C, constitutes a nuisance under the governing documents of the association, but does not constitute a public nuisance pursuant to NRS 202.450, or D, is a violation of the governing documents of the association, but is otherwise lawful under the laws of the state. Number 3, if a violation of a provision of the governing documents of an association poses an imminent threat of causing a substantial adverse effect on the health, safety, or welfare of the unit's owners or residents of the common interest community, the executive board may not impose a fine that exceeds $10,000 for each violation. Any fine imposed pursuant to this section is subject to the fine appeal provisions of NRS 116.31031. Number 4, this section does not preclude an association from pursuing any other legal remedy authorized by law that is available to the association. And that concludes section 2. So we will now turn to public comment. We'll start in Las Vegas on section 2.
Good morning, commissioners. My name is Greg Kerr. I'm attorney at the law firm of Wolf, Rifkin, Shapiro, Schulman, Rapkin. I'm also a member of the Community Associations Institute Legislative Action Committee. And I'm here today in my capacity as a member of the LAC committee. The committee, we met yesterday afternoon to discuss this particular section of the proposed reg. We had a number of different changes and thoughts that we were kind of discussing. After that meeting, I had sent some red line changes to the division. I don't know if any of you got them or had a chance to read my comments. I did send them late. So after the workshop, if you take a look at those. But so for purposes this morning, what I'll do is I'll just kind of give some of our general thoughts or concerns or maybe recommendations on the proposed reg. There's a few things that kind of caught our attention, and it has to do with where the proposed reg cites to these particular criminal statutes determining what is a health, safety, welfare violation. A few things that kind of come to mind are, one, the way, of course, we understand the health, safety, welfare designation to work is that there has to be some underlying governing document violation. And then if the nature of that violation is such that it can be deemed a health, safety, welfare, then this regulation would come into play. I think with citing to the criminal statutes, my concern, maybe even a question for the commission or the division is that are those criminal statutes the basis for the violation? And if so, that runs into a problem potentially because associations don't have the jurisdiction to enforce those things, right? The association, of course, limited in its jurisdiction to enforce governing documents. If there is some violation of this criminal mischief statute, for example, the association doesn't have the ability to really deem that to be so unless, the state does. And so there's a question of, is the reg as it's proposed, is there also an additional conviction requirement? For example, if there has to be a conviction first, and then the association can say, oh, hey, this homeowner, this resident has been convicted of this, mischief statute. Now we can proceed with, health, safety, welfare, even assuming that there's also an underlying violation of the association's own governing documents. So that was kind of the concern. The changes that I had submitted yesterday tries to address. I mean, I think conceptually, it makes sense. We want those violations that we're treating as health, safety, welfare to be serious enough, right, to warrant that designation. But I think we need to be careful whether or not we're having associations step in to be that police force to make those determinations as to whether or not somebody has committed a crime or not, or has even in violation of a, for example, paragraph E in or subparagraph E1 talks about violations of housing or health codes. You know, if a homeowner builds something in a room addition in their backyard, and the association believes that it violates the city's setback requirements, and so we send them a violation notice. Hey, you're in violation of the city's setback requirements. But you call the city to say, well, we don't have any open violations against this homeowner. And the homeowner says, I've never been cited by the city for. So it's putting the association in that position to make them make those determinations where I don't think they have the jurisdiction to. So what on behalf of the committee, what we had proposed in terms of our changes were more of describing the nature of the conduct that could be considered health, safety, welfare, which when you look at those changes, they look similar to some of the things that you find in those criminal statutes. But at least it's giving the association its own discretion based on its own governing documents to make those certain those changes. So those are kind of the general comments. Please take a look at the comments that I submitted on behalf of the committee yesterday. A few other just sort of specific notes. There was a reference in the proposed reg to the fine appeal provisions. So basically, if the health, safety, welfare fine exceeds 10,000, any such fine is subject to the fine appeal provisions of NRS 116-31031. I don't find any appeal provisions in that statute, so I'm not sure if that was a mistake or maybe I'm just missing it. But I did note that as well. Also, last comment in paragraph 1 of the regulation. It says, without limitation, and then colon, then it goes to list on all the different things that can be considered health, safety, welfare. I eliminated without limitation because I think that by having if this is not an exhaustive list, then we still have a lot of ambiguity as to what health, safety, welfare actually is. So I would prefer, and then on behalf of the committee, I think we would prefer a definition or a structure of health, safety, welfare that's defined here, where we only look to here, where we don't say, well, it's without limitation, so you can consider other things too that aren't here, right? So it's sort of, it builds back in this ambiguity that I think we're trying to avoid. So I think that's an important note. But otherwise, please take a look at the comments that I submitted yesterday. And I suspect there'll be continued dialogue. This is obviously just a workshop, so there'll be changes and thoughts and comments along the way. So I appreciate the committee's time on this. So, thank you.
Thank you. Any other public comment?
Morning again, Mike Kozar for the record. Let me start by saying this is not an easy problem. It's been out there since 2005. The legislator put this in writing 2005 and it yet to be determined or defined. Okay. In 2011, the industry, actually 2021 rather, brought it again and said, hey, we need to get a definition. And the legislature says, yes, go out and get you one. So this is not an easy situation to find. And I agree with Mr. Hurd that this doesn't do it. That what's currently before you should not be accepted, and there needs to be a lot more work there. Number one, from a homeowner's perspective, I'd like to kind of put in the front of your mind that you are giving a set of volunteers that probably have very little legal experience, if any, and very little board experience, the opportunity to levy $10,000 fine without limits. That is a huge opportunity. And opportunity for abuse by the small number that wish to do that. So please keep that in mind. If you don't have clear guardrails, this could get to be a real problem. Okay? It shouldn't be a convenience statute. I've been on many boards, and it is very difficult to get the public agencies that do a lot of the things, the criminal statutes, the code enforcement, to actually come out and do what your association would like it to do. So it becomes convenient for the board to then add on. I would caution against that. Okay? And from what I'm seeing here, most of what's done from a board perspective is after the fact. Yet the statute or the proposed regulation reads imminent. I just don't see how you reconcile those two properly without some clear examples. The legislator wanted criteria, as was previously discussed, specific things that a board could turn to and say, yes, that looks just like this. We're seeing the same thing in our community. We would like that to occur here. Big question I have is, why are we now doing this? Is there sufficient evidence, data that shows that we need to give this kind of authority to a homeowners association board? We already give them the opportunity to fine $1,000 and up to $1,000 per meeting. What more power are you wanting them to then possess? And what is the value of that? California, by the way, has a similar code. It doesn't use the word welfare, which makes it a big difference. It points to a property that's damaged. That's clearly in a homeowners association's bailiwick. But when you include it to be overall welfare, now you've expanded this to a much larger prospect. So I very much caution you to be careful there. As far as specific criteria, I agree with what was said previously. There's a number of items here in the statute as written that needs to be. Right now, it's so broad. I'll point out to one. It says, quote, actionable misconduct under the state penal codes. That is huge. Okay. And as was previously stated, I don't believe that falls within any authority. I'll also hit what was also brought up. There is no appeal process that I could find either. So now you're giving a board this kind of power, and the only appeal process is our civil litigation system, because that's really all that's existed. Lots of problems here, folks. And I think the task before you is huge. And there's a reason since 2005 it hasn't been defined. But this isn't going to do it. And I look forward to working with you. I'd love to see, hopefully it'll get posted, some of the comments from the previous speaker and CAI, so that we can work together on trying to come up with what really does work, and hearing from the commissions as well. Thank you very much for your time.
Thank you. Any other public comment? Oh, we've got another one.
Hi. I'm Mark Lee. I'm the board president of Mountains Edge Master Association. Just coming from a board member perspective, for me, health, safety, welfare fines are kind of a scary proposition, because ultimately, if you don't pay health, safety, welfare violations, we can take your house. The board has that power. But I know that there are boards that don't have that kind of apprehension to using health, safety, or welfare. The other problem that I see is that with the language, I'm wondering if it's possible where a homeowner or a group of homeowners can come to a board meeting and try and coerce the board into action. Like, for example, if a group of homeowners realize that there is a registered sex offender living in their community, can they come to the board and say, well, you guys need to do something about that, because this person poses a threat to the community. You need to start finding them. That would be a scary proposition for a board to say, well, no, we're not going to do anything about that, when we have the power to do so, given by the division. And on the other side, if you've got a board that is very willing to use health, safety, welfare, can they use that to start policing their own community and say, well, we're going to get rid of all these people that are convicted of crimes because they pose a threat to our community. That's all. Thanks.
Thank you. I'm not recognizing anybody else in this room. Carson City.
There are no members of the public out here in Carson City.
Okay, thank you. Any virtual comments regarding this section of the proposed changes to the regulations?
Do we have anyone attending virtually who is interested in commenting on section 2? I am not recognizing anybody online.
Okay, thank you. Thank you. So we will move to section 3. A person who is aggrieved by an alleged breach of the fiduciary duty set forth in NRS 116.3103 and who files a written affidavit with the division pursuant to NRS 116.760 must specify in such an affidavit any statute, regulation, or order that the complainant believes the member of the executive board has violated in breach of such a duty. And that concludes section 3. Short. Okay. Any public comment on section 3? Nothing in this room. Seeing Carson City.
There are no members of the public out here in Carson City.
Okay, thank you. Any comments virtually on section 3?
Do we have anyone interested in commenting on section 3? Please use the raise hand emoji. Yes, Laura?
Hi, good morning. Is this going to be the part where all the bullet points are, like process for imposition of health and safety violation?
No, Laura, that was the previous section, but I think we can, but you can still provide your public comment on section 2.
Okay, because I did have my hand raised. I want to speak on behalf of the gentleman that spoke earlier, I don't know who he was, that talked about the health and safety. Sorry, I'm getting feedback on my thing. As far as that goes, is in our HOAs, I'm noticing that the $5,000 per violation is adequate. And like the two previous gentlemen stated, these board members are volunteers with little to no training in either legal or real estate law or anything of that nature. So I do support the need for clear guidelines on the health, safety, and welfare violations. The current framework pretty much relies too heavily on subjective discretion of the untrained executive boards. And we're kind of seeing a really, what I think is, I've lived in a HOA now for about 12 years, have had a little bit of a legal issue myself recently that I'm still involved in. And there's like an imbalance where the boards use these HSW designations to fast track something or to find someone that they have an issue with or a friend of theirs or whatnot. Sometimes they'll fine you for foul language, and maybe you use the F word in a sentence, like "don't effing tell me that," and you get fined thousands of dollars. And like the gentleman said, they threaten to take your home for things of that nature. Your appeal status. The board is volunteer. They run in cliques and they only take care of their friends. So again, that high dollar going up to 10,000, I think really needs to be readdressed and get more people in the room like the gentleman that just spoke previously. So these boards do lack training. A lot of them don't even go to the NRED training for the ombudsman to understand the NRS. So with their lack of training, they can't distinguish between a nuisance and a true safety threat. So that result isn't just a financial burden, it's a failure of the association's core duty to protect us, the homeowners. So I would also urge the commission to possibly include some mandatory external verification, training, specialized training requirements before a board can bypass any standard fine limits under that health, safety, and welfare imminent threat provision. And I agree with the guy, it's imminent threat. That word right there creates some question as to if it happened 6 months ago, things of that nature. So maybe some decision-making type of training, like mandatory professional consultation rather than just your attorney, who tends to, I've noticed the attorneys that are in-house tend to lean more toward the board decision because I think it's their contract kind of clouds their decision making at times. Same thing with the management companies. They don't act enough. Some specialized board certification possibly in how to evaluate these. And maybe a different board, the external, you know, just a different oversight committee to look at these to make it more fair, and not get so carried away with homeowners losing homes or money over something that's insignificant versus loss of life threat like we've had recently in our town. So with that, I do have a couple other bullet points I would like to comment on later. So I'll let this kind of be my comment, and thank you for listening.
Okay, and for the record, that was Laura Cantor, Canter. Remember, when you do make public comment, to state your name and spell it for the record. I also have Julie, who has her hand up. Julie, would you like to speak? Unmute yourself and speak.
Yeah, I'm here with I'm here with Julie. This is her husband, and my name is Bruce. Last name Snyder, Snyder. And just the comment is, we live in a small community of 20 homes, and my concern is, I'm sorry I'm a little late on the game here, but with health, safety, and welfare. But we've had 2 fairly substantial SWAT raids, just one house over from us. And I'm wondering if the committee has any comment on that whatsoever, obviously with respect to health, safety, and welfare, and what the board's obligations, what they can do, what they can't do, what limits are. I know we obviously have CCNRs and but I don't think they address that in particular. But the SWAT raids were at really very substantial periods of time in terms of very, very early in the morning, and it was incredibly disruptive. And one very, very late at night that lasted until 3 o'clock in the morning. So, and these certainly are concerns with flashbangs going off and wondering whether or not they're going to be gunshots flying through our neighborhood, which we were told is certainly the potential. So, I'll defer to you, and hopefully somebody might be able to give us a little bit more insight on with respect to our board. Thank you.
Thank you. Any other virtual public comment on section 2 or 3?
I am not recognizing anybody else looking to provide public comment on section 3.
Okay, thank you.
So move to section 4. During an investigation conducted pursuant to NRS 116.765, the division may provide to the subject of an investigation a list of remedial measures that the subject of the investigation may take to be in compliance with the provisions of this chapter, Chapter 116 of NRS, or an order of the commission or a hearing panel. A remedial measure provided pursuant to this section does not constitute disciplinary action, but failure to take such action may be considered by the division to be good cause to proceed with the hearing on the alleged violation. And that concludes section 4. So we'll move to public comment in Las Vegas, section 4.
Again, I provided written comment that should be part of your package on this particular section. It's small, but it's a bit subtle. I am in support of this section, provided it gets amended. Let me clarify. The intent of the statute is clear, that the division is the investigating authority and this body is the adjudicating authority. What this provision will permit is an investigator to determine that, yes, there was enough information to believe there's a violation, and then get it remitted if the violator or to be violated, because you're the only ones that can make them a violator, but the person that's going to be violated, okay, would do the following things. Now, I'm all in favor of an investigator, just like you would like your DA to be able to go to somebody and say, hey, if you stop this, we'll no longer pursue litigation. And I believe the division should be able to do that. Okay. But they should not be able to do that in confidentiality where we have no idea what's going on. Where we have no idea what were the remitting provisions that they agreed to. What was it that you thought they were violating? All of that would then be done because of the way confidentiality works here. It'll all be done in secret. And there would be no visibility. Homeowners themselves would not know. Let's say a board does something, an investigator, books and records is a classic one, refuses to, investigator looks at it and says, look, I think you need to do this. You need to turn these over or you'll be in violation, which I think is currently going on informally. That ought to be then brought up and it ought to be available to the public. So we know that, yes, the investigator determined that my claim under the IA that I submitted, in fact, was valid and that there was remedial action that was required so that the homeowner has confidence in the division and in the process that it's going to work. Right now, there's no violation. There's no requirement to tell the homeowner what occurred. Okay? There's no information that comes forward as to what happens. So this little provision, if it does not have the proper guardrails, and I think they can be added in. If we say, yes, you can do this division, but when doing so, you need to make public what it was you did, then I think that's exactly where we ought to be headed. But if we do not, if we just give them this authority and then say to the division, fine, go ahead, make these changes because it streamlines things, and it would. What we've done then is we've created some transparency problems that I think that this board, this commission needs to address. So I hope that I'm kind of in support of it, but not as written. It needs to be amended so that this authority then does not come without the transparency that's required. Thank you very much.
Thank you. Any other public comment on section 4 in this room? No. Okay, up to Carson City.
There are no members of the public out here in Carson City.
Okay, thank you. Any public comment virtually on section 4?
Do we have anyone who is interested in providing comment on section 4? Please press the raise hand emoji, or if you're on the phone, press *6 and state your name. I am not recognizing anybody with a hand raise. Oh, wait, hold on. One moment. Laura Cantor, go ahead.
Hi, Laura Cantor, Canter. I just want to say I concur with the gentleman that just spoke. Thank you.
Now there's no one else looking to provide public comment.
Thank you, Mr. Sue.
Yes, thank you. Bill Sue, Deputy Attorney General for the Division, providing public comment in regard to Mr. Closer's comment. The statute of confidentiality is NRS 116.757. Essentially, in order for the division's investigation, any part of it to become available to the public, there has to be a formal complaint filed. And so, while I understand Mr. Kozler's point, and frankly, a lot of people's points regarding transparency and the desire for an IA not to go completely poof into the wind. Logistically speaking, if we were to try to achieve that goal with this statute regarding confidentiality, I don't know how we would achieve that short of filing a formal complaint in every instance that we want to then disclose those details to the public. So I don't know if that's something that we can maybe work around, but the legislative intent on that confidentiality was pretty clear. We need to respect that as well. So I just want to recap.
Okay, thank you. Section 5.
So move on to section 5. Number 1, an interested person may file a written petition with the division to adopt, file, amend, or repeal any regulation that is within the authority of the commission. The petition must identify the change that the petitioner is requesting and contain any relevant data, views, and arguments relating to the change. Number 2, the administrator shall consider the petition filed pursuant to subsection 1 within 30 days. If the administrator denies the petition not less than 30 days after the filing of the petition, written notice of the denial must be provided to the person who filed the petition, stating the reason for denying the petition. If the administrator does not deny the petition within 30 days of the filing, the commission shall review the petition at the next feasible scheduled meeting following receipt of the petition and render its decision and proceed accordingly. Good section 5.
Looking up for public comment in the room on section 5.
Sure, I don't have, Mike Kozar, which I don't have comments on everyone, just you happen to be logged in the front. I promise. First of all, number 5, let's look closely at what that one says as well. And by the way, I'd like to come back. I do not agree with the council from the that the legislature intended confidential to be interpreted as we are currently doing. That's a question for the commission, and there are ways around it because most other agencies get around confidentially and publish reports with redacted information so that the public is aware of what's going on. But that's going back. On to number 5. What this says is with regards to how a petition is to be filed. As you know, brought to your attention, I filed a number of petitions that have not been heard by the commission. They've been sitting there since July. They've not been refused, but they're not being moved forward either. They're not even on your agenda. They've not been on your agenda. Okay? So essentially, the way the statute's written now, lacking the regulations that I believe should be provided, is that they could sit there forever and never come forward. Number 2, because the division doesn't bring it to you. So unless you ask for it, unless you know of the petitions that I filed, which you should be under the statute, the whole purpose of this is so that a regulator cannot get in the way of a petition. It either has to be rejected in writing or it has to be processed. Right now, it can do neither. And that's what the point I'm trying to make here. As it's currently written, and I provided you again written comment, and I provided you with a proposed change to the regulation as it's written. Okay. Once the administrator, if in fact, first of all, the commission wants to let the administrator have that authority, it's not clear to me the statute gives the administrator that authority. But understandably, from an administrative perspective, I would be willing to say, okay, the administrator can in fact make that decision to deny it, provided he puts it in writing, because now as a homeowner, because I can bring it before the commission and say, hey, look, here's what the administrator says, I don't agree. We have then appeal or some due process there. Okay. But my next point then is once he does not deny it in that 30 days, it needs to come to the commission. What's currently written here is it comes to you for your decision whether it can get denied. The statute is clear. You have 30 days from the time you get it to the time you have to make a decision to deny. If the administrator sits on it for 25 days and then doesn't move forward, sends it to you and you don't get to it in the next 4 or 5, by law, it has to then be heard. Now, what you can do is he can send it to you and say, I don't deny it. And then when you get it in front of you, you can say, we've looked at it and we're not going to proceed with it, or we've decided that it doesn't have merit or whatever, but you can't not just not consider it. And this is where the regulations come in. Okay? I do not agree with counsel in the AG's office that the APA standalone is sufficient. The APA provides some general background and some general guidance, but it actually requires by statute that the rules that you're going to operate under be made available. And I've asked for these rules. They don't have to be regulations, but they have to be some kind of rules. Rules of practice, I think they call it in the terminology. But the public has to have availability to it. So the question I have is if I provide a petition and it doesn't get heard in 30 days or being denied, what is the rule you're now operating under or the administration's operating under to then bring it to you? And I've asked for that rule and I haven't gotten it. So therefore, what is it? That's what the law wants. It wants transparency. What is it that we're going to tell the people to do? Okay? So that's why I have a little problem with the way this is written. I'm all for the administrator being able to say, nope, we don't think it complies. What I don't believe though is that's written, that's really what it does. Okay. So thank you very much for your time.
Any other public comment in the room on section 5? Okay, not recognizing any, we'll go up to Carson City.
There are no members of the public out here in Carson City.
Thank you. Any virtual comments on section 5?
Anyone interested in providing comment on section 5, please click the raise hand emoji, or if you're on your phone, press *6 and state your name. I am not recognizing anybody interested in providing public comment.
Amy. Okay, section 6, I will ask you to turn to page 7. That's where the change is, towards the bottom of page 7. So just for record, I'm going to read starting at M. Yeah. So 1M, I think it is. So NAC 116.425 is hereby amended to read as follows. And M states a general statement describing the objectives of the funding plan that is designed to allocate the costs for the maintenance, repair, replacement, and restoration of the major components of the common elements and the methods used in projecting the 30-year funding plan using the following terms and discussing, where applicable, number 1, full funding, and number 2, threshold funding. And there are no other changes in that section. That concludes section 6.
Okay, any public comment in the room on section 6?
Morning, Commissioners. Rob Forney, Forney. I'm a reserve site specialist here in Southern Nevada. And this baseline funding issue is a big one, given that you have to save up 100% of every component, every project's cost. It doesn't save any money to be baseline funded. A $10,000 project every 10 years is $1,000 a year, whether you're baseline, threshold, or whatever. So it's very irresponsible if you only have 1% of the money and it doesn't do anything. You still have to save 100% of every project's cost. So it's a very important issue, but NAC 116.425 only talks about things that we have to include in our reserve study. And then M says we have to talk about the general objectives of the funding plan and talking where applicable about baseline, threshold, and full funding. I think we'd all agree if a reserve site specialist was to recommend a baseline funding goal, it should be talked about. So just saying you don't have to talk about baseline funding doesn't preclude someone from doing a baseline funding plan, right? So it's only saying we don't have to talk about it anymore. So I don't think it really accomplishes preventing people from doing baseline funding goals. And I will also mention this, even if it did, even if it was by statutes illegal to recommend a baseline funding model, threshold, they're all thresholds. You know, baseline is a threshold of 1%. Full funding is a threshold of 100%. And the threshold is anywhere in between. So even if you say we can't do baseline, I can still do a threshold of 2%, you know, which is basically the same thing. So that is my concerns. I would recommend either not changing this or making an amendment to just say in Nevada, the funding goal has to be a threshold of at least 70% or greater. Everyone, if you were to ask any community manager what adequately funded means in Nevada, they'll either say 70 or 75%. So I think it would be a great idea just to tag that as an actual funding goal and sort of solidify what we already agree on anyway, which is that all associations in Nevada should be 70% funded or better. That is all I had to say. Thank you very much.
Any other comment, Las Vegas, for section 6?
Not my promise.
Okay. Warm. Okay, Carson City, any public comment on section 6?
There are no members of the public out here in Carson City.
Okay, thank you. Any virtual comments on section 6?
If anyone is interested in providing public comment on section 6, please click the raise hand emoji, or if you're on your phone, press *6 to state your name and state your name. I am not recognizing anybody with public comments.
Thank you, Amy. So we'll move to section 7. The changes are actually, they'll be on page 11, towards the top. Section 7, NAC 116.520 is hereby amended to read as follows. I'll read number 5. The funds used to subsidize a proceeding for mediation pursuant to the section must not A, be applied to the fee required when filing a written claim pursuant to NRS 38.320 or any attorney's costs or fees associated with the claim, and B, exceed $600 or $300 for each party who is eligible to have the proceeding for mediation subsidized pursuant to this section, whichever is less. And that concludes the changes for section 7.
Any public comment in the room on section 7? I'm recognizing none. We'll go up to Carson City.
There are no members of the public out here in Carson City.
Okay, any virtual comments on section 7?
If anyone is interested in providing public comment on section 7, please click the raise hand emoji or press *6 and state your name. I am not recognizing anybody who is interested in public comment at this time.
Thank you.
Thank you. So I'm going to read actually 8, 9, and 10. Let's get there as written. Section 8, Chapter 116A of NAC is hereby amended by adding thereto the provisions set forth as sections 8 and 9 of this regulation. Section 9, the term classroom, it means a physical location or electronic platform through which live instruction is provided. And section 10 is live instruction, means instruction provided by an instructor who, number 1, is physically located in the same room as the student receiving the instruction. Number 2, uses electronic means of communication to provide instruction through an electronic platform in such a manner that the person providing the instruction and the student receiving the instruction are separated by distance but not time. Or number 3, uses any combination of methods described in subsections 1 and 2.
Okay, any public comment in the room on sections 8, 9, and 10? Okay, not recognizing any. Carson City.
There are no members of the public out here in Carson City.
Okay, thank you. Any virtual comments on sections 8, 9, and 10?
Anyone interested in providing public comment on sections 8, 9, and or 10, please press the raise hand emoji or press *6 and state your name on your phone. I am not recognizing anybody interested in public comment at this time.
Amy. Section 11, NAC 116A.005 is hereby amended to read as follows. As used in this chapter, unless the context otherwise requires, the words and terms defined in NAC 116A.015 to 116A.095 inclusive and sections 9 and 10 of this regulation have the meanings ascribed to them in those sections. So I'll just include them for section 11.
Okay. Any comments on section 11? Okay, none in this room. Heading back up to Carson City. Any comments on section 11?
There are no members of the public here in Carson City.
Okay, thank you. Any virtual comments on section 11?
Anyone attending virtually, if you are interested in commenting on section 11, please click the raise hand emoji or press *6 on your phone and state your name. I am not recognizing anybody interested in public comment at this time.
Thank you. Section 12, NAC 116A.138 is hereby amended to read as follows. Upon the expiration of a temporary certificate pursuant to subsection 1 of NAC 116A.137, the division shall issue a certificate to the person who held the temporary certificate if the person, number 1, remain employed by the association which made an offer of employment to the person or an agent of the association during the 1-year period that the temporary certificate was valid. Number 2, has completed not less than 60 hours of instruction, which meets the requirements for instruction in courses in the management of a common interest community set forth in paragraphs A and B of subsection 1 of NAC 116A.120. And there are no other changes in section 12.
Okay. Any public comment in this room regarding section 12? Okay. Carson City, any public comment?
There are no members of the public out here in Carson City.
Thank you. Virtual comments, any on section 12?
If there's anyone interested in providing comment on section 12, please click the raise hand emoji or press *6 on your phone and state your name. I am not recognizing anybody wanting to give public comment at this time.
So section 13, it begins on page 13, but I will direct you to page 16 where the changes start. And I'll start with reading numbers. Section 13 NAC 116A.325 is hereby amended to read as follows. And it says a management agreement must, so we'll move to number 6, except as otherwise provided in a management agreement. Upon the termination or assignment of a management agreement, the community manager shall, within 30 days after such termination or assignment, transfer possession of all books, records, and other papers of the client to the succeeding community manager or to the client if there is no succeeding community manager, regardless of any unpaid fees or charges to the community manager or management company. A, the records required to be transferred include without limitation. Section 1, all books, records, documents, correspondence, data, files, and other materials of the association in the possession, custody, or control of the community manager or community management company, regardless of format, medium, location, or age. Number 2, all records required to be maintained or made available pursuant to NRS 116.31175. 3, financial, governance, contractual, legal, and operational records customarily maintained in the management of a common interest community. 4, electronic data, data reports, and reasonable access information necessary to allow the association or succeeding community manager to access and use electronic records transferred pursuant to this section. B, records must be transferred in a reasonably usable format. Number 1, electronic records must be transferred in an accessible electronic format unless otherwise agreed. Number 2, the community manager may retain copies of records solely as necessary to comply with applicable legal or professional obligations. C, at the time of transfer, the community manager or management company shall prepare a written inventory identifying the categories of records transferred. Number 1, the inventory must identify any categories of records that do not exist or cannot be located. 2, the inventory must be signed and dated by the community manager or an authorized representative and must include a certification that the inventory is true and complete to the best of the signer's knowledge. 3, a copy of the inventory must be provided to the client association and, if applicable, the succeeding community manager. Number 4, the succeeding community manager and or client shall review the inventory of records within 90 days of receipt. Back to section D, if records required to be transferred pursuant to this section are later identified as omitted, the former community manager or management company shall promptly transfer those records upon written request unless the former community manager certifies in writing that the records do not exist or are no longer in the possession, custody, or control of the former community manager. E, notwithstanding any provision in a management contract to the contrary, not less than 40 days before any termination or assignment of a management agreement, the secretary or other officer specified in the bylaws of the association community manager shall, number one, in a common interest community with 100 units or more, post notice of the pending termination or assignment in one or more prominent places within the common elements of the association. And two, provide electronic notice of the pending termination or assignment to all units owners who have provided the association with an electronic mail address. And that concludes section 13.
Thank you. We have a public comment, section 13.
Good morning. My name is Jan Porter. I'm going to give you a little bit of a history lesson because I've sat in your shoes before. When the first commission was put together, Gail Anderson was in charge and kind of instructed us that a lot of the stuff that we were dealing with was the carryover from 645. And one of the problems with this particular section is that we see in practice that management companies are identifying their own terms of their own definition of what a termination or assignment of management agreement date is. Some are saying, well, they terminated us for the end of March. So 30 days after the end of March is when this comes in. If you read NRS 645.580, it provides for the reader a clearer definition. Now, it kind of comes in on page 18E to define where that termination comes in, but I think it can be more clearly defined if you take NRS 645.580, look at that language because it specifically states step one, the client terminates the broker by doing X, Y, Z and how that's done. You kind of hit it in section E, but we do have in the real world management companies that say, well, we're terminated March 30th. So by April 30th, you'll get this. That doesn't serve the association. It doesn't serve the successor management company at all. So I'd like for you to take a little extra time to look at that in relationship to how the real estate world. And I know it's comparing oranges to clementines, but that's kind of how the division looks at HOAs. We may be the clementine and they may be the navel oranges, but we try our best to work together with what we got. Thank you.
Any other public comment in the room regarding section 13? Okay. Carson City.
There are no members of the public out here in Carson City.
Okay. Virtually, any public comments?
If there's anyone interested in providing public comment on section 13, please click the raise hand emoji or press *6 on your phone and state your name. I am not recognizing anybody interested in giving public comment at this time.
Let's move to section 14. Section 14 NAC 116.8.350 is hereby admitted to read as follows. Number one, if a person who alleges that a community manager is guilty of misconduct sends the allegations of misconduct in writing to the community manager in an attempt to resolve the issue without filing a complaint with the division, the community manager shall, in good faith, acknowledge and respond in writing to the person making the allegations within 12 working days after receipt of the allegations. Nothing in this subsection shall be construed to require a community manager to acknowledge and respond to any allegations sent by the person that do not allege misconduct of the community manager. And then I will direct you to page 19 for the second change to the section, which is at number 3. Upon receipt of a complaint that complies with subsection 2, the division shall forward the complaint to an investigator. The investigator A shall provide notice of the complaint to the community manager and the executive board of any association which relates to the subject of the complaint. And then I'll go to number 4, which is on page 20. Upon review of the written report of the investigator, if the administrator determines that grounds for disciplinary action against the community manager exist, the administrator may take one or more of the following actions as deemed appropriate. And then there are no other changes in that section.
Okay, public comment on section 14. I'm not recognizing Carson City. Any members of the public present?
There are no members of the public out here in Crescent City.
Thank you so much. Virtual comments on section 14.
If anyone's interested in providing public comment on section 14, please click the raised hand emoji, or if you're on your phone, press *6 and state your name. I am not recognizing. Oh, I apologize. Yep, Julie, go ahead, Julie.
Hi, good morning. My name is Julie Snyder, SNYDER. I am a board member in my small community, and I was recently viewing some of the invoices, and one happened to be an invoice to an attorney with regard to another board member bringing some kind of questions to him regarding a board member. And since our board is small and there are very few of us who have difficulties with each other, wondering whether or not there are ways to find out what the reasoning is behind a board member using HOA money to discuss things on a personal level with regard to another board member. I hope that makes sense. Thank you.
Thank you. Any other virtual comments?
No, I am not recognizing any other raised hands for public comment.
Sharice, I think we're going to pause here for a 5-minute break and come back for the last section.
I'll just read the last section.
Well, are you sure?
Yeah, we can do this.
You do? Okay. Okay, no, that's fine. You know, if we want to power through the last section
Okay,
before a break, that's fine.
get more time.
Okay, yeah, let's do that.
Okay, section 15. NEC 116.435 is hereby amended to read as follows. The executive board or a person acting on behalf of the executive board shall submit a summary of the reserve study to the division pursuant to subsection 4 of NRS 116.31152 by filing electronically, if possible, the summary on a form prescribed by the division. Number 1, upon receipt of a reserve study prepared pursuant to subsection 2 of NRS 116.31152, the executive board of the association shall A, review and adopt the reserve study no later than 210 days after the association receives the initial study, and B, adoption of the reserve study shall be documented in the minutes of the executive board meeting in which the adoption occurs.
Any public comment in the room regarding section 15?
Rob from the or NEY. I think next committee meeting, I'm going to fly up to Carson City just to give them something to do.
Yeah.
I love this section. This is so great. The 210 days was taken out a couple of years ago, and I was really sad to see it go. Adding it back, I think, is extremely important. We have clients that will make the process go on forever with the reserve study, and then they'll just change something at the end, and they'll say, "Oh, we missed something," and we might even know they've already submitted their 609 form and that they're changing the study without re-reporting findings to the division. But there's not. It puts us in an awkward position because the state, their requirements to the state, it does not bind us with our contractual obligation to them. So we have internal policies and procedures where we will put a cap and say we're not going to do that. I'm not sure if my peers have the same policies. So I would like, this would put us all on the same page, and we could say, listen, it's been 210 days since we first gave you the draft. The statute says you have to send in the 609 form, which means you've already had to adopt it. We can't make any changes. And that's important, not only because we don't want the study to drag out on and on and on, but also my report has to be accurate as of the date on the study. So if I revise report today, but I didn't do the site inspection until like 8 months ago, I can't say the asphalt was in good condition. And the person reading the report says, oh, this report was prepared today. They would assume that everything in the study is accurate as of today, but it could have been, 300 days earlier. I think 210 days is a great time because, the bigger communities, sometimes it does take them a long time to vet their reserve study, and they might have finance committees, et cetera. Reserve studies are always done for the upcoming fiscal year. So right now we're doing studies for fiscal year 2027, but 7 months from now would be in like September. So I think that gives every association plenty of time to adopt and finalize their study and put it to bed. So thank you very much.
Thank you.
Once again, Mike Kozar. I kind of come at it totally differently. Not that I disagree that these shouldn't be sitting around, but that this isn't the right process to do. I went back and looked at and try to find the history of NAC 116-435, and with all of Sharice's great capabilities going back the many, many years it takes to find that, we could not find the history of it. Okay. So my question is, why does this exist at all, given where the legislature is? The legislature already requires that the HOA submit within 45 days every 5 years a report to the commission. That's the law. Okay. What this does is says a board shall adopt what is provided. A contractor is going to give me a study and I'm required by law to accept it. That doesn't make sense to me. Some associations will do it at 2-year point, 3-year point. Things change. They want a new study. Just because I get a study doesn't mean I have to adopt it. Okay? And that's what this regulation would require. So I understand the concern that it can sit and be dated by the time it's adopted. That's a valid concern. This doesn't solve that problem. Okay? If the study needs to be no later than, or must be initiated no later than, then put that in the law so that a board cannot approve one that's over 210 days. What this says is you got to approve it because I gave it to you. And I think that's a mistake. Big mistake. So I would suggest you get rid of the NAC altogether, or you reword this so that it makes it clear that the study can't be so old at the time of approval. Thank you very much.
Any other comments in the room regarding section 15? Okay. Any comments in Carson City?
There are no members of the public out here in Carson City.
Okay. Virtual comments on section 15?
I do have Byron, if you'd like to speak.
Yes, Byron Getting, Goetting. So I agree with Rob that I am in support of having a set time frame to limit the amount of time they have to review and adopt the study. And whether or not they are required to follow the adopted study, that would be another point. My big concern is this section, along with section 116.427, that defines the commencement period as the previous site inspection date. This easily puts most most boards don't really need to adopt the study well into the next year. So as Rob mentioned, we're preparing our reserve studies for 2027 now. All these dates and timeframes should be tied to the budget going out, and adopting a reserve study after you've made a budget gives them the opportunity to not follow the reserve study whatsoever. And then if you get a financial update every year, but you always do the financial update after your budget, the, on paper, it looks like you're doing everything right, but the reality is you made a trick on how to not follow your reserve study. So I would strongly encourage this section to be rewritten and also make amendments to NAC 116.427 to not tie the reserve study to the previous site inspection date, but to some deadline for the budget season. And a great analogy of this that I was recently told by another one of my peers is, tax deadline is April 13th. If you got your taxes done early last year, there is no regulation that says now you have to get your taxes done by when you started last time. No, it's always April 13th. The deadline for a reserve study should be some date prior to your budget, 30 days, 45 days, however many days, but prior to your budget. And that is what we should focus on, not when we should start the reserve study, but when we should finish. Thank you.
Thank you. Do I have anyone else who is interested in providing public comment on section 15? Please click the raise hand emoji or press *6 and state your name on your phone. I'm not recognizing anybody else interested in public comment.
Okay, so let's take a 10-minute break back at 10:45. Thank you.
Amy, are you ready?
Yes, we're ready virtually.
Oh, but Carson City, look, he's all right, Rob, we get to see you again.
Yeah. Carson City is ready.
Okay, great. Thank you. Okay, so we last left off, we read through each of the sections of the regulation and public comment was provided. But we do have another opportunity for members of the public to provide any public comment on any of the sections that were read into the record, which were sections 1 through 15. So if there's any final comment on the regulation, any provision, please feel free to come on up. Okay.
Good morning again, Jan Porter. I just want to touch on section 4 and listening to the comments related to the concerns for transparency. In relationship to this, it says this section does not constitute disciplinary action. My question was, I don't have a problem with the transparency provided that the subject topic, so say it's NRS 116.31175 request for records, if that shows up in the investigator's report to the commission. Because as a person who writes classes, I will take a look at the investigator's report of, what are the biggest issues? Where do we need to provide training for our boards? Where do we need to provide training for managers? And so if it's 31175, then we can address that. So as long as the transparency, I don't care who did what, I want to know what I need to train for to provide better education value for board members and managers. So I don't have a problem with the transparency, provided that the topic of the concern is kept in a report to the commission. Thank you.
Thank you.
Mike Kozar again. I'd like to also touch on that section 4, and the comments was made. The assumption is, my assumption was that this was an IA that was actually submitted. So AG's comment that doesn't necessarily have to be the case. If the commission's going to go out, if the division's going out to do investigations unrelated to an IA, then that's not what I'm talking about. I'm talking about formal IAs that are submitted and what are the results of those. I am also not worried about if everybody's going to act appropriately. But unfortunately, in this day and age, we don't write laws to keep that identify our norms. We write laws so that people don't break our norms. Okay? And so if we have a regulation that allows us to then obscure what's going on, for instance, that same idea of let's say it's an election, send out too many ballots on an election thing. And the division decides, you know what, this is kind of a vague rule. We're just going to kind of let that one rock. We're not going to match anything, although we believe that, you're actually in violation, but we're going to let you off on this one. Okay. Now relationships come into play, and we don't get the visibility we needed as to really what was the problem. So the investigation gets concluded. The person that filed the complaints told that they found no violation, and that's where it dies. But in fact, there's a lot more to it. So what that a lot more to it needs to be, if we're going to allow an investigation to be closed, then the reasons why, if remedial action is provided, ought to be public. What was the remedial action that was provided? What is the public reason? But that does not then run into a confidentiality problem. You can delete whoever the investigator's name was. You can delete the person's name and the association, all the things that might be confidential. But the fact that this was a division decided that this is what they wanted to do. Remember, there's a reason why the division is only given jurisdiction to investigate. That is unusual for a regulator, and I understand why the division's pushing back on that. Normally, regulators have more authority than just investigation. But that's not the way the law is written, and the law gave you all the authority to adjudicate, not them. And what you're doing is you're handing it back. You're giving them the discretion. And if you're going to do it, make sure you outline that discretion clearly. Thank you very much.
Any other comments on any workshop topic in the room? Okay. Carson City, last ask for comments regarding the workshop.
There are no members of the public out here in Carson City.
Okay, thank you. Any comments virtually?
If there is anyone interested in providing a final public comment on this workshop, please click the raise hand emoji or press *6 on your phone and state your name. Julie, go ahead.
And just one more question. I was quite well informed during this meeting, and I was hoping that there would be more workshops. Is there a time frame that these occur, or should I just check the calendar? Thank you.
Offline.
Okay. Okay, we can address that offline regarding any specific questions you may have regarding that process. Any other comments virtually regarding this workshop?
I do not recognize anybody else with their hand raised for public comment.
So with that, we'll go ahead and close the public portion of today's regulation workshop and open it up to the commission for discussions. We want to go section by section. Okay, let's open it up to section 2 regarding the health, safety, and welfare violations. Mr. Gilliam?
Just a comment. I would really like to see the red lines that Mr. Kerr mentioned. So if those could be sent over just for review, I think that would be really helpful. Tend to align with a lot of the things that were said during that public comment. And then my only other thought on that, there's a lot of information here, right? Like, I think we got a lot more than last time and maybe now need to dial it down just a little bit. And then I think this question was asked last time, but it's with regard to the $10,000 for each violation. Is that cumulative or per occurrence? I think that's it for me. I'll come back if there was anything else.
Mr. Chair, whenever I'll,
sure.
Or if we want to go down the row. Okay. I share some of those concerns. As I look through section 2, specifically, I do think that there can be guardrails, and look, like, context I will submit on this is I was the city attorney in Mesquite for 8 years, which is like just all HOAs, like everything.
Yes.
And as I read the way that this statute and some of the comments that were made earlier, I mean, I'm thinking about, and look, I'm a lawyer, it's annoying, right? But I'm thinking of crazy hypotheticals, right? Like, there's an obscenity, offends public decency. So in what world does that happen when, like, you hate your neighbor and you happen to be on the board and your neighbor's out back sunbathing, right? Like, there's a very viable complaint that, like, any person sunbathing in any way, shape, or form might, you know, offend public decency, especially because the HOAs are not subject, they're not lawyers, they're not subject to judicial precedent, they're not subject to what the courts think that means. I think there's some issues. I think about scenarios where, like, you know, it's Memorial Day weekend and some dumb drunk dad gets on a scooter, an e-scooter, and he's not, like, over the limit or anything, but again, that could, there was some language in here, annoy the comfort of a considerable number of persons. The SWAT team, I think, was a great example earlier. If SWAT comes into a neighbor's house and bust through the door. And I would submit to the question that was asked earlier. It says per occurrence. I was a prosecutor for many years. I think there are at least 30 to 50 different violations I could think of that occur during a SWAT raid that could be put on the owner of the home. And if we're talking, even 10 at 10,000, that's 100,000. At 20, basically at the value of a small home. So I have a lot of concern there. And then to Mr. Kozar's point he raised earlier, I am not, there is, I know in section 3, I think we'll get there, there's reference to an appeal process. I'm not as familiar with it. I'm trying to figure it out under that statute, but I don't really see a clear appeal process here. I do think that if, to the extent that anything like this is adopted that gives HOA boards this level of power, the commission or the people should have some level of check on that, just besides the civil court system, because it's incredibly expensive, it's incredibly complex, and we're giving an immense amount of power to HOAs if we were to do this. And so there needs to be some regulation. And I would submit, last comment, sorry, I would submit that to the extent relevant and we do adopt something like this, there should be something that if it's appealed to either this commission or the division or a court or wherever, and it turns out that it's not, it doesn't fall legally under those rules, and they're decided against, that either the association and or the member responsible for driving the issue is responsible for opposing parties' legal costs, something along those lines, because I just see a world of absolute like chaos from HOAs, which is, that's a scary, I'm gonna move to Australia if that's the case. I mean, that's bananas. Just one commissioner's opinion.
Commissioner Morse Jarman. I concur with Commissioner Sweeney. This whole section gives me grave concern. I could see some types of HOAs ramrodding homeowners and thinking that they are the Gestapo law. I think that we need to really pay close attention to the wording of this and to redefine it and to cut it down to the point where it's clear cut and very objectionable in terms of what these HOAs can do. This gives me heartburn.
I have a lot to say, so I'll go to Commissioner Tibbetts.
I mean, I don't actually, Commissioner Tibbetts, I echo some of the same sentiments here. So I don't have anything really to add. I think the appeals process seems like needs to be addressed if we are going to go with something like this. So yeah, I don't have anything to add. It hasn't been said.
Okay, Commissioner Haydarian for the record. So associations already have the authority to do this. It's already happening. They have the authority to enforce their governing documents and deem something a threat to the health, safety, and welfare of the association, its residents. I think the issue, and I'll ask the division for their comments, is that it's sometimes unchecked. There's been great comments. A volunteer board with little to no training, how do they determine that something rises to the level that could support this sort of fine and potential foreclosure? As a manager, fellow managers, are we in a position to determine something and guide our boards? Oh, that's health, safety, welfare. It's thrown around a lot. There's not a lot of understanding. It is probably used where it shouldn't be, in smaller instances where it's, we've talked about the dog poop or the tall weeds and things like that. And there needs to be more education as far as what is a threat. The boards are fiduciaries and supposed to defer to their experts, which also includes getting legal advice, talking to their experts, understanding the pros and cons. Is this justifiable as a health, safety, welfare? What do they see as far as attorneys' experience? Fines that are reasonable and that could stick. They're always going to be challenged. They're always going to be appealed. I think that's a good thing because the fines are to gain compliance. And so sometimes once you issue the fine, you need to have an opportunity for the homeowner to finally come forward and discuss what has been going on. Also, I want to comment, this is already allowed, and let's not forget the expectations of the unit owners living within these communities. they expect these association boards to enforce the rules that are already there. We're not creating a new violation. The boards want to enforce the rules that are already there. So I do have still a little bit of concern about, outright excluding nuisance and the practical application. I do like outlining that these particular instances, property damage, physical assault, all of those behaviors, and seeing it will help the boards govern and help outline, okay, these things are a threat to the community. But we talked last time, I believe, a lot of the associations, all they have is that nuisance provision. And as you've heard, Mr. Kerr, who's an HOA attorney, say, first you have to have an underlying violation, and then you can deem it a threat to the health, safety, welfare. So if we outright prohibit a nuisance, perhaps then boards need to adopt those anti-bullying resolutions and separate policies. So now it's not just a nuisance. There's a violation of the association's governing documents via a policy. So those were kind of my notes. And these types of situations are going back to managers and my fellow managers. These types of situations happening in our communities are outside of the day-to-day scope of our management agreement, of our license. So we should be encouraging our clients to go and seek legal counsel. And sometimes it's going to move forward and sometimes it's not. But there's a lot going on right now in community associations, and maybe the division can touch on what they're seeing. But we all have our opinions from our viewpoint, but some of the behaviors that are going on right now are terrible. And to take away or, inadvertently limit what associations can do to help get this behavior to stop, I think we just need to be mindful that this should be the last resort, not something that's day to day. It should be 1 in a million situations, not we've got 5 this year. Unless there's chaos in the entire community, maybe there's an issue there. So I do have a question of how did we arrive at the 10,000?
Thank you, Shara Chandra, Administrator for the division. So the 10,000 number. So if we go back and kind of look at how this kind of evolved over time, essentially in the legislature there were concerns about the foreclosure process. Right, that's how this all started. What are the things that can create a foreclosure situation? And one of them was violations of health and safety. So if you are deemed violating health and safety, then could potentially lead to foreclosure. So the question became, what is health and safety? And every association has their own understanding of what that is. So all those scenarios that have been described right now are currently happening. So it's now what we're trying to do is kind of narrow that field of what is considered health and safety. So essentially in the legislature, my recommendation was let's bring it to the regulation level to actually discuss these very issues more detailed, because the legislative level doesn't allow for this kind of a dialogue and discourse to kind of understand what the key issues are. So hence we're here. It is controversial because at some level we've heard the situations where what happens if someone fires a gun? What happens if there's a SWAT? What are the repercussions? So that's considered health and safety, but also, what things are not. So our goal started off with saying, okay, let's try to tier these in the egregiousness of the violation. And then we got a lot of feedback. Well, these tiering things won't really work. And then sometimes the fines were like 500, 1,000, and those were too less because they don't prevent this kind of behavior. And so what we settled on was up to. So it doesn't have to be 10,000. It's up to. Now that's the number. We could drop it to. It's really a number because we had gone from 500 to 1,000 to something else, and those were just felt that those were just too limited. And so we kind of went over here and put a kind of a line and said not more than that, depending on the egregiousness of the violation. So that's where the 10,000. So we're completely open to any kind of number. if it's 5, and that everyone, there's a consensus that that's pretty okay to leave at, we can adjust that number however we want. We don't have any data, so it's hard to kind of come to a number. So that's one thing. The other issue was when we first tackled this was because if you are going to try to define certain actions as violations, it has to be at a statutory level. Regulations, we don't want to define anything. There's statute. So our next step was to try to, with Crystal, try to figure out if there were statutes already there in NRS that kind of define these things, health and safety items. So those were kind of the list of things that we found that said, okay, if there's a violation of public nuisance, it's already defined in a different statute. So we could kind of mirror that, and that way we don't have to worry about defining these things. So that's kind of where we went. And so it's not an exhaustive list, but now it looks like we've kind of went and got all these definitions, and it kind of became a little more expansive than it should be. So now the comment is, let's maybe dial this down within those to kind of define certain areas. And so, yeah, that's where we started. And now we've kind of come here. Now we're going to come back to the middle. So that's kind of how I'd envision this process also, is to try to figure out that middle ground, because ultimately it looks like what we want to do is anything that's not in here is not a health and safety. And so, an association could potentially have rules and regulations around what is a nuisance and all those things, but they're not health and safety. But the minute it crosses that line and it meets one of these requirements, it becomes health and safety. So that kind of is the idea behind this. So right now, there's nothing. So if someone comes and says, oh, this may happen if we do this, it probably is already happening. But hopefully our goal here is to narrow that range of things that can happen, put a cap on it. And so obviously that would be, if you do something that's a violation of a regulation, then you are also subject to division action and commission action too. So it kind of moderates it and brings it to our level. That's really the idea. Conceptually, when we talked about process, we may have cited the wrong statute. We'll look at it, but really the fine appeal process was similar to a regular appeal for a fine. You'd have to notice, you go appeal it, 30 days, 60 days, whatever that appeal process was. We wanted to tie this into the same thing. This is no different than anything else. And obviously, because it's in regulation now, if there's a violation of a regulation, then you're subject to an appeal and a commission, division investigation and a commission. So it does bring it back into our purview. So that's right now, we don't know. So that's another area that, again, putting guardrails around it. How much can we put around it? I don't know. But I think it's better than what we currently have. I appreciate the process because this is kind of how it should be. We started off being very general. Now we're kind of getting very specific. And then now we want to kind of bring it back into the middle where if there are certain things that we see under, as an example, public nuisance as defined in NRS 202-450. So maybe we revisit that definition of NRS 202-450 and select out items that we believe are public nuisance and then just put that in here as language. Then it's very specific to those violations and nothing more than that. And so maybe that's where we work through to bring that in here. That's one thought I had. But other than that, that's really kind of the intention here. The next, really the ultimate goal is we want to have it in a regulatory form. But if we're unable to come up to some decision, it may have to be a statutory change. And really at that time, what that statute looks like, I can't really say. It might be too broad, it may be too punitive, it may not get, and that creates a whole set of other problems. And so I think We'll go back and we'll tweak it a little more, but the goal here is to kind of develop a more firm consensus towards the next meeting. So we have something that everyone says, okay, it's not perfect, but let's move to that next step. Because right now there's nothing. So potentially all those things that Commissioner Sweden you're talking about are just haywire, right? And so maybe it's something that we at least wrap our arms around.
Yeah, I don't dispute that. I mean,
And so that's
if dads are driving their e-scooters drunk, the HOA should be able to regulate, right? Like, I will concede that. I just was giving some examples, like, I agree. And thank you, Cheryl. Yeah.
And so if we say it's not in here, then you're not violating health and safety.
Yeah.
So that's at that point, whatever your rules are, you can administer them. It's not a violation of regulation, so you're good. But if it is, then now there's consequences. And we will definitely, Commissioner Gillian, will look at those comments. I think that's where their direction was also. It seems like, again, from what I hear, they seem to be coming around to this kind of general idea that if it's in regulation, then it's kind of, controlled. And I do agree, some of these statutes we haven't fully explored. So there could be other things to Commissioner Sweden's point that are kind of beyond the scope of what this should be. But conceptually, and this is where the attorneys are going to help us, conceptually, I just look at it as one violation, right? It's health and safety one. It's not within one, did you violate 16 different things and then it's 10,000 for everything. That's not how I envision this. It's just one. And then if you don't pay it, then there's some recurring consequences and then that's it. But if a SWAT thing attack comes to your house twice, that's two things, right?
Yeah, that would be fair. I would concede that SWAT comes to your house twice. You have bigger problems in your HOA fines at that point, probably.
Thank you, Commissioner.
We're getting those, sorry, Shrews Bates. We are getting the comments printed and they're being brought up right now, so.
And this is Senior Deputy Attorney Crystal Keegan. I'll just add too, because I know there was some question about the correct citation we're on section 2, subsection 3. I believe that it to be the correct reference. It's 116.31031, section 4B2. We pointed to that because it's the right to contest an alleged violation. And so the intent in referencing that was to provide that written notice and right to contest process, not necessarily to create new appeal rights, which when you look back at the authorizing statute, the legislators charged us with establishing criteria, not necessarily creating this whole set of new appeal rights for this. And so just wanted to put that on the record. As far as the penal codes there, tying into that. So it's my understanding this kind of came up with trying to address bullying in communities and things like that. And so when we looked at Nevada law, that was really specific to the education system under NRS 388. And you saw it in cyberbullying in the context of minors, NRS 200. And so we tied them to specific crimes: harassment, assault, battery, property destruction under NRS 200 and 206. And the idea there was to have a predefined objective framework to avoid this arbitrary decision making. And so in practice, when a board is determining a fine commensurate with a violation, they can use that as a reference point. It also might help streamline coordination with law enforcement. So that was the idea there. There was a comment about under section 2, section 1E about tying into the health and housing code. So we did consult the Attorney General's office on this, and they suggested tying into NRS 118A. That's the landlord tenant laws about a dwelling unit. And so we included that language there. Just wanted to quickly address that. And then there was a comment under section 2, which goes into what doesn't pose an imminent threat. 2A uses foul language. And so the comment about fining for use of the F word, you would say that that's addressed there in that section. Let's see. And then just as Administrator Chandra said, as far as the 10,000 per occurrence, correct, the idea is that the fine is commensurate with the severity per occurrence staffing limit, and that's why we drafted it governed on the severity and it provided a specific regulatory count. So the opportunity to make those decisions.
Thank you. Commissioner Haydarian, for the record, I just have some final thoughts. I think this is important to put the guardrails, because sometimes boards won't take action because they're not confident either. If what they're doing with proceeding with health, safety, and welfare violation fine is appropriate, or there's obviously misuse of this provision. So I think it would be helpful to clarify, absolutely. And there were some comments about associations not enforcing the law, right? And referencing to those references to those other statutes. But there are some governing documents that state that any criminal act is a violation of the governing document. So I'll give an example really quick. A unit owner was using illegal drugs in his unit, set the place on fire, and we're looking at least $300,000 in property damage, including neighboring units. So to tell an association, oh, that's okay, that's $100, the damage could have been more severe. People could have died. And so luckily they have a provision in their governing documents that criminal acts is a violation. And so they were able to consult with their attorney and come up with a number. I mean, what they want is for this to cease. They want the behavior to stop. And so if that is their only mechanism, and of course, also public agencies taking whatever action they can to be able to get this to stop. I think we should be careful not to, there's no way to know every instance, every scenario, there just isn't, but to just arbitrarily try to narrow it, so we just can't. I mean, we have to give the associations the authority to take whatever action they can within their very limited authority to get, to protect the association. So I will rest on that. Thank you.
And Commissioner, if I could just, can I say one thing?
Sure.
Just responding to Deputy Counsel Keegan's comments, the language used in the regulations appeal provisions, and the way I read 116-310-31 is that's before a fine's implemented. That is a process and a notice, an opportunity to cure. I understood these particular issues to address something different, which is kind of these imminent harms where they can impose a fine. I think it's probably an easy fix language-wise, like the fines that are issued here under Section 2 follow the same process. The HOS will follow the same process as that statute reference. I have a lot of concern using the term appeal provisions because neither the word appeal shows up. And I would submit that an opportunity to cure prior to imposition of a fine is not necessarily an appellate type procedure. That's a curative action ahead of any enforcement action happening in the first place. And then on the language, I do agree, F word probably not enough. I think the concern I'm hearing from the public is like, if a board member perceives that F word in the context of fighting words or threatening words, then it could be carried over. And so, and I will submit, I've never been in a fight at an HOA board meeting, but I've read about a lot of them, and they happen all the time in Mesquite. And there's a lot of things that get said that I think reasonable minds could disagree or agree on what's threatening and what's not. And so that would be my only word. I would say if the board members on the receiving end of the comments, I would just be happy to place a bet they're going to think they're fighting words typically if they can do something like this, because it's a really nice hammer to like stop what a board member might perceive as just kind of generally disrespectful conduct rather than actual threatening language.
But sometimes the F word explains exactly what you want to say.
Oh, I totally agree, Commissioner. I fully agree. That's why it cannot be illegal. You have to still be able to use it.
Commissioner Haydarian, I'm sorry, I have one more comment I did not write down. There's been some comments about imminent threat. So in the HOA world, it's not a violation until it's already happened. We warn everyone about the rules through mailing of policies, procedures, governing documents. That's the precursor. We've already notified everybody. If you do these things, you're in violation. So now addressing it, it's always after the fact. There is no way to predetermine. This is why we have, well, schedule of fines and things like that, but associations can't do anything until the action actually happens. And in these instances, a lot of times the actions are really egregious and harmful to individuals, to the association. And so again, keeping that in mind when we try to put some safeguards in place. So thank you. Are we good on section 2? So section 3. My only question is Commissioner Haydarian, how does section 3, any changes impact what the current process already entails?
Rod Chandra, Administrator for the Real Estate Division. I'll let Crystal chime in here too. Really, this is to provide more clarity to the division when we're investigating, so we get more details rather than just cite a 3103. Just generally, we need more context and more information, and so this is just to solicit that information.
Senior Deputy Attorney Crystal Keegan for the record. So that's correct. We see 116.3103 abused. Basically, it was suggested by our compliance section to strengthen the complaint process. The issue is that division gets complaints about just general dissatisfaction with their board or personal conflicts. And so this clarifies that an alleged violation needs to be grounded in a legal obligation. So that was the intent there.
Thank you. No comment. No comments. I'm hearing none. Commissioner Haydarian, I love it. Everything is procedural, and if there is a serious, true breach or alleged breach, there should be facts and data supporting that so that you guys can properly investigate it and we can take the appropriate steps. So that's my only comment. Are we good to move on to section 4? Any comments by my fellow commissioners to section 4?
This is Commissioner Tibbetts. I'm just confused. So maybe just ask for help. Because I feel like I've heard a couple different things about the confidentiality. The idea of an investigator investigating something and having remedial actions, I think is great. Question is, how do we make it so it can't be understood what's happening and it's not done in secrecy? We never find out about that. So just help me understand. I don't understand.
I'm going to try to attempt to explain that. It's, and then Crystal could chime in. Also, so essentially, confidentiality requirement is if the division does an investigation and then closes it with without any action, then that whole process, that file is confidential. And it's across a lot of statutes, just protects the people that are being, in the case of licensees, people can complain all day long and then be investigated. Now, if you say every investigation is open, then suddenly the perception is that there was, issues with that licensee or there were all these complaints. So unless it's substantiated, and then at that point, it comes to the commission for adjudication. At that time, all of those documents and the files are available. So in this case, what happens is the division, our goal is to kind of keep improving the process to make sure that we address some of these transparency issues and questions. So what we've been doing and we've tried to do is when we do close something, we try to provide as much explanation to both parties. What happened, kind of without getting into the nitty gritty of the investigation or the documents pulled so we try to provide that information. So in this case, so for example, normally if something comes to the division and an investigation happens and there's no real, violations of 116, the case is closed and some information is given. in this case, a lot of times, we would like to ask the other party, though there may not have been violations, we feel like there could be some remedial actions that the party should be taking. And so we provide that as part of the investigation. And a result of that, we'll say, okay, if you do, please do all of these things to make sure that you're in compliance going forward. And then someone just says, no, I'm not going to do it. So that now gives us an ability to bring that person to commission and say, here, they did not follow these requirements the division recommended that they do, and hence you're here for that. So that's really the difference. So if a complaint came in and the division investigated and found violations, we'd bring it to commission, or we'd have a settlement, which would come to the commission for review and move forward. So that's the progression. So there is a gap where it may not be a violation. It may be some issues that we may want to address. This gives us a mechanism to do that. And if they don't follow through with that, it gives us the second mechanism to actually bring that to commission.
Question. Commissioner Gilliam, so the process you're talking about, like a letter of instruction would be the remedial suggestions, right? A letter of instruction. So you would let the complaining party know a letter of instruction was issued, but you wouldn't go into the details of what the items were, or would you?
I think to some extent we try to explain, here are the items and then here's the remedial action that we've taken without going into the entire,
Because how would then, as the follow-up to the letter of instruction, if they violate, if the person or group did not follow the letter of instruction, how does the division know that it wasn't followed?
That's a great question. I think most of it is through the complaint process.
Another complaint. So they would open another complaint, though, in theory. Would they have to go through that entire
Not
IA
necessarily.
process again?
No, not necessarily. And so this is where, it's not one-to-one. Potentially, the division would have some in place.
Wait, hold on 1 second, sorry.
Check with Amy, are you still
Yeah.
there?
I'm back,
Okay.
but we had a break. Yep, we had a break. So you may want to recap that last little bit, please.
So to answer your question, if there is, how do we know if they didn't follow through? As part of the letter of instruction, compliance section has some checks to make sure that those are done. And so if they're not done, or we get pushback, or we get, we can't get this done, or for whatever reason, I think the investigator at that time will say, okay, so you're given a time frame. Normally, letters of instruction have time frames around them. 90 days, within 60 days, please respond with these remedial actions or something to that effect. And if those are not done, then now the compliance section has the ability to then bring that to the commission for non-compliance of these items that are listed. So that's just the way to.
I don't have any questions.
Did you,
I mean, I think I understand. So I think it's fine.
Crystal, did you have anything to add to that?
Senior Deputy Attorney Crystal Keegan for the division. Yes, just to kind of piggyback off of what Administrator Sean just said, having seen the letters of instruction, they typically have a deadline in them. So it'll instruct you fail to, notice the unit owners 21 days prior to, a particular structure or using, some sort of funds. And so we will instruct them to hold the meeting, and then there's a follow-up in that regard. But as far as the confidentiality piece, NRS 116.765. So that can't be altered by regulation. It's how we understand that statute. It's anything short of a formal complaint being filed, that's confidential. And that's not unique just in this instance. You see that across the board for police departments and things like that. The investigation it's a confidential piece. And so the idea here is that it doesn't necessarily broaden secrecy or anything like that. It simply provides an efficient pathway for compliance. As far as introducing this section 4, into the regulation, if the intent was to provide that the division can take these remedial actions to ensure compliance with 116, which we are already doing. And it's not creating authorization because we're already allowed to do this under 116. That's 116.6152. We can do all things necessary and convenient to carry out the provisions of the chapter. So we have broad authority to enforce and administer the provisions under 116. And so we are saying that this aligns with our remedial functions. And when you look at 116.745 through 0.795, it's set up as a progression enforcement model. So this is one piece to that before it gets to here. Thank you.
So Commissioner Tibbetts, on that, if you already have the ability to do it, why are we adding section 4? I am not following, like, if we already have the ability to do it and we're doing it anyways with this letter of instructions, why go the trouble of adding this section?
Again, this is Senior Deputy Attorney Crystal Keegan. It's basically to clarify, and that's why we introduced it as far as just a remedial measure. And then we clarified it doesn't constitute disciplinary action. And then it ties into 116. I think it's 765 as far as that good cause piece to proceed to commission. So.
Commissioner Hadarian for the record. So I think it's helpful to clarify. And I agree with the step process and be able to follow up. I would just want to ensure that these steps are being taken after an investigation conducted pursuant to 116.765, where there has to be a written affidavit. It's got to be a formal complaint. It's got to include the details of what we discussed in section 3, and fully investigated, right? And then a letter of instruction is given with the remedial action, because we're seeing these letters coming through based on an email to the division or a phone call, nothing investigated pursuant to what the law says with the process. So I just want to make sure. I love the idea of giving the remedial measures, because like you said, they go nowhere sometimes. Okay, well, nothing was found. And so because we're not guilty of any wrongdoing, we're not going to do any of this. And then following up on it, I think I do understand the confidentiality part of it. So is there any way that once these are closed and a letter of instruction or whatever action is given, that the division give us quarterly a report of here's how many letters of instruction were issued and here were the topics? Because I do agree, if we don't know what's going on in our industry and what the violations are with regard to either a certificate holder or boards, how do we get the education out there and continue to train on these things and guide our boards if we don't even know what the subject was? So I think maybe there's a mechanism for you to share what was found, just the subject of the matter, so that we have an understanding of what the issues are. And that might appease some of the clarity type questions.
Yeah, I agree, Commissioner Chair, fully with that. I mean, I think for me, not working in the way you do and some of the others here, I would say it seems just kind of a matter, and what I thought I heard from some of the comments, like just a matter of general transparency. There's just an idea of, hey, this is generally, if you're in this ballpark of penalty, here's what we're going to do. And I think it's also a good way for the public, the interested public, to track what are the general violations coming in and how are they being resolved. And also, as a former government employee, I fully appreciate like the state has like actual people that have to type that stuff out. So definitely like willing to listen to feedback from the division on that component.
Commissioner Morris Jarman, I concur. I think that the transparency is really important. And once, like you said, Chairman, if the industry doesn't know what the violations are, they don't know what to look for and how to pigeonhole it. So I think that transparency is a big.
Chair, Sharat Chandra, Administrator for the record. So I think you made a comment earlier too. So this would be a regular complaint that would come through the same process. That's why the ombudsman's there, for the phone calls, for the emails, for the mailbox where I have a question, I have concerns, how do I address this? Got a problematic situation, let's talk through it. That's the role of the ombudsman. But when it comes to the investigative section, yeah, this comes through that regular formal process. So there's no letter of instruction potentially that goes out to an association that they don't know anything about. There's that same process, except this adds that one more step of enforcement ability that allows them to correct some actions and then with some remedial actions. And if they don't complete this, then it gives the enforcement section the ability to then hold their feet to the fire and say, you haven't done these things. And so either you can fix them or you can come to the commission and, present your case here. And so that's really kind of, I think, the determination. We do have ways to report, most common things that come through. We'll try to maybe we'll think through it. Maybe we can provide a sample of what kind of letters we send out as, closure letters, or when we require these letters of instruction, what goes out to both parties, like a sample of how much detail goes in there versus how little goes out, so you can get an idea, because I think you need some context to see what actually goes out and if that's informative enough. Because the goal is really to inform the other parties that we did look at it, and here's some of the things that we looked at, and it may not have risen to this level, but here's some remedial action that was better. Maybe we can work on something.
Commissioner Darian, does this apply to certificate holders as well? Or is this just for intervention affidavits against?
I believe it's IAs right now. It's only it talks to 116.
So I think it would be helpful as well to understand what things are coming through for the CAMs, where there needs to be more instruction, better education, especially if it's consistent in one area, then that means the industry needs to be better about the training that's being offered. So.
And I think we do, but we'll maybe try to bring it up a little more into
Okay.
the thing, so it's more visible.
Question, does the industry hold, say, for instance, an annual meeting to discuss the issues that are happening within the industry, within the state, so that they can better address what's happening? Or is it just come as come?
Commissioner Haydarian, there are other organizations, like the Nevada Association of Community Managers, Community Associations Institute, that have their own memberships and gatherings, and they discuss these things.
But there's, Commissioner Morstromik, there's no collective group that says we need to address this. And I'll give an example. When we were dealing with the automotive repair industry, we literally got together with all of the new car industry owners and the repairmen and everybody involved. And we sat down and said, these are the issues that are coming before the commission, Consumer Affairs Division. And this is what we propose as solutions. Now we need you to get on board with working with us to solve these types of problems. And we greatly reduced a number of the issues by working within the industry. So my question is, I guess there is no collective body that does this, that says, hey, we got problems.
Not a singular. Yes,
But
there are others.
And that's a problem. Because the left hand doesn't know what the right hand is doing unless you communicate. Correct?
I would agree with that.
So how do we solve that? Because if you're going to solve problems within the industry, everybody needs to come together at one point. Even if it's only one time every 3 or 4 years and say, okay, look, we have a proliferation of these issues that we need to address and find a solution to before we leave out of this room today.
Commissioner Haydarian, I feel like I think that's the goal of the division and ombudsman's office and this commission, but every organization's reach only goes so far, right? I mean, when you look at the number of people who are members of these organizations or actively involved, 3,400 associations in this state, and it's less than 1,000 people or 1,000 people. I mean, we're not reaching the masses at that level. So that's a good point. Maybe someone should take that up.
My term is over in October.
Okay, are we ready to move on to section 5? So this is Commissioner Haydarian. I believe I have a general understanding of this section and how interested parties can submit their petitions to the division. The administrator has 30 days which to address it. And then I heard some comments that there was some confusion of the 30 days and when it would come to the commission, but this proves to me that if the administrator doesn't deny the petition within 30 days, then it comes to the commission at the next reasonably available. So I don't know that I have any questions. It's pretty straightforward.
Seems straightforward.
Sure, Chandra, Administrator of the Real Estate Division. So I think there was some concern that we didn't have anything in regulation that talked to that process. And so this was an attempt to clarify that process and make it clear, but that's really it. So essentially, yeah, if you are interested, petition the division, you do that. We have 30 days to respond. And if you don't respond or, allow, then it comes before the commission and there's a specific process for that. And so it comes to the commission for consideration. The thing to remember with regulations is these regulations that we propose, this is our second public workshop. There's a lot of public comment. Someone shouldn't just be able to just come in and say, change the rules and here's what I recommend to do. That doesn't work like that. It works where it has a robust discussion and there's all these interested parties that talk about it. And so that's important. So we want to craft a process where, yes, if someone has a petition for a regulation, then that gets, discussed. But then eventually the commission has to say, hey, this is something that we want to kind of look into a little more. Can the division work this into a future regulation or something that would make sense? Now, the division may come back and say, we tried, but, here's what we believe achieves that. And then you get all this public comment that says it's a great idea or it's a terrible idea. And then we move forward. And that's this process. This health and safety regulation we came up with, and now we're open to all kinds of public comment and, discussion and ideas on how best to craft it. And so if someone comes and says, I think you need to change this because here's my explanation and here's what I believe needs to be done, that's great, but that's still your opinion. And so this is a forum for us to bring it to the commission and say, commission, take a look at this. And if you believe that there's something here that we can consider, then we would. So that's really what this articulates a little more clearly. And is it perfect? No, but this is pretty much how the process should work. And that's what we try to clarify in this.
Commissioner Haydarian, this is where I think having the data, at least a summary of things that you're seeing through the division, it may align with some of the topics that people want to see changes. So if we see something's very pervasive, then we can discuss, right? But if we don't know what's coming through the division, if it never comes to the commission, we can't really measure if there's a topic that needs to be discussed further, whether or not we take any action on proposing regulation changes. It'd be nice to see, is this really an issue? Other than just relying on one or two folks coming forward from the public.
Commissioner Gilliam, I agree with you. It would be nice to see what the administrator was denying so that we had an idea, right? Like we might say, well, shoot, this is of importance to us, and when we think we should talk about it. So if we could see what was also being denied, just in a quick summary sheet, we don't have to have a huge conversation about it, but I think that might be helpful as well.
Commissioner Morris-Jarman, the division does wonderful reports. And I think it would be beneficial if you, maybe quarterly, did a summary of what you're seeing and put it on the website. That way everybody has access to it and they can say, well, we're also seeing this. Maybe you don't have complaints on it yet, but we're also seeing this. Maybe we want to red flag this particular area. Because obviously there's some problems out there that need to be addressed industry-wide. So now is the time to really start looking at this and trying to come up collectively with some type of solution to some of these issues.
Sure, I Chandra, Administrator of the Real Estate Division. Yeah, well, we'll definitely do that. I think that's a good idea. And we do have a newsletter, so we have ways to make this kind of more public. So we'll work on those things.
Else on this section? Okay. Then that takes us to section 6 is the reserve study and the removal of the word baseline. Baseline funding.
Commissioner Gilliam, if I may, I agree. Mr. Forney was who commented on that section. And I would agree with what he says. So maybe just a rewrite to address the fact that a threshold can be any percentage. So maybe defining that a little bit better. Obviously, the laws it states right now with regard to the funding of reserves is pretty ambiguous, that it must be, what does it say? Adequately funded? What does adequate mean? So, so I think that would be helpful.
Commissioner Haydarian, also, I had a note here. So in working with reserve studies and associations, I've also heard reserve study specialists say, if you have no money in the bank, but all your projects are done, are you adequately funded? Right? So setting a percentage, then you start getting into deferred maintenance and that kind of thing. So I don't know if I think the industry would love that percentage finally narrowed down. So, but I don't know if it's in a good way or a avoidance way of like, well, the state says we only have to be this percent. So as long as we don't have to address any of the other things in the reserve study. So it's a moving target. It's tough to, but going down to a certain threshold, but not doing the projects, I think that's a bigger issue.
I think Commissioner Gilliam, I don't disagree that I think a baseline funding should not be allowed. It is really tough when you have an association that has been on a baseline funding method, and then all of a sudden a new board comes in and says, oh, wait, we want to do a new study and they're doing full funding. To get that association back into a place where you get that new study is extremely challenging. And so then they just sort of, I think, carry on with a baseline, even though maybe they know that that's not the best decision. So I agree. I think baselines should be eliminated. I agree. Setting it at a specific 70% is challenging because every situation is a little bit different. So this will be a challenging one.
Commissioner Tibbetts, however, if you don't establish what threshold funding is, I mean, Mr. Forney, I mean, you could just go 2%. So I think there has to be some definition there.
Commissioner Haydarian, also on the flip side, 100%, 200% funded and no work's being done because associations tend to think we have to get to 100%. 100%, that's all their focus. It's not the actual maintaining the community. And it's not, and the number fluctuates every year when we do the budget. It's a moving, like I said, it's a moving target. So, but yes, letting it get to nothing or 100% and not doing anything, I think that's also.
Good.
Madam Chair, just one follow-up comment on this so we understand it. And I think everyone touched on the key points on this. So again, we're putting a threshold funding at a certain percentage. That's a can of worms that I don't know if I want to open right now, because like you said, there's so much more there. But at least removing baseline, at least moves us to a point. It doesn't maybe do anything per se, but at least got that language out. So now it's threshold funding. Now the threshold funding is 2%. That's whatever that practice is. Hopefully, then we start moving towards some more achievable targets. But the goal here was just to eliminate something and not kind of leave it in there. But the larger point we understand, and Sonia has been working with this, reserve study task force to make kind of changes and recommendations to regulations, but also think about statutory changes that we may want to propose. Because, I mean, I think all of us are now familiar with some of the issues that happened in Henderson with the community where the pipes under the ground leaked. And so the issues. So again, it goes down to your reserve study. What do you have? How much money do you have available? And so that's a problem that's going to continue on because we've got aging stock and it's going to continue. So this is one of the areas that we need to focus, not just the only area, because we want to make sure that a community, an older neighborhood, a community, smaller community has access to funds to take care of the roof, whatever. Those are the things that need to get taken care of. But we also don't want to put threshold funding at like 70%. And then now suddenly half the associations are non-compliant. And then now that creates another can of worms. Or like you said, communities focus on just the funding and not really caring about. So it's a blend. And so the first thing was to get rid of the baseline funding. And I think we did that hopefully through this. And then we'll continue working on solutions. But the regulation here is pretty robust. We just need to probably define things a little better. But I think we'll look to some recommendations from that task force also.
Okay, do we want to break for lunch here?
Ms. Allen. Should put us about 12:40.
Sure.
So unless, I mean, Shri Chandra, administrator for the record. So again, unless commissioners have specific things that they want to discuss, because we're going section by section, just like we did the public comment, you don't need to. You can skip around. If there's things that you made notes on that you want to talk through, let's do it. If there's nothing, then we don't have to go through it. So
Everyone's in agreement with that. Yeah. Okay, well then we can skip these. So this is Commissioner Hadarian for the record. I had a question on section 8, 9, and 10. Just if you can touch on the need to clarify. It's just language that needs to be cleaned up or why now?
thank you, Shri Chandra, administrator for the record. So yes, why now and needs to be cleaned up? Yes, to both, because I think it originally started with real estate, where real estate education required in-person training. But when COVID happened, what is in-person training? And there was all this confusion. So, and also we need to get with the times. So online, as long as it's live, is considered. And the thing with changes is if you don't put a definition in here, you can't really make those changes. So we wanted to define the classroom and what live instruction was to allow for, online coursework and live instruction. So that's all. So that's the only change. And we just inserted it here. We're doing that to all our regulations across 645 also.
There any other comments on those? This need? Okay. This is Commissioner Hadar. We'll skip to section 13. And the proposed language amendments to. I don't really have comments on the record transfer. I like that clarity there. It's all over the place. We need some structure there so people understand. At a minimum, this is what we're talking about. But I want to talk about the just the practicality of the change in management company, so the termination or assignment of management agreements. Having it be the notice to the members of the association not less than 40 days before a terminated contract or an assignment, I think that needs to be clarified. I think Ms. Porter made a comment. What is the actual termination date? Is it the day that they get notice that their agreement is being terminated? Is it the last day of management? So if it's the last day of management, absolutely, the member should have already been notified that there's going to be a new management company. But 40 days before that, I don't think that's practical because sometimes associations find out on the 30th day, hey, we're giving you a 30-day notice, or the association terminates the management company with a 30-day notice. There's no way the association can get out a notice to the membership that, hey, in 40 days, we're moving management companies. I just, from a practical standpoint, and I also made some notes too. And I guess it kind of touches on record transfer. So management agreements vary as it comes to the termination of the agreement and when the transition can actually start. So there are companies that say both parties have to give a 60-day notice either way, but we will not start transitioning until 30 days. So if that's the case, that puts the association in a, they could give more than 40 days notice, but really nothing's going to happen until that, first date within the 30 days of transition. Also, I think we need to consider once the homeowners know there's a new management company, they will start sending all of their inquiries to the new company. The new company doesn't have authority. The new company doesn't have any information, any records. And so it just creates a little bit of a strain because we have to tell them, no, you need to go back to your current management company. And then they feel like no one's helping them, right? So how can we, I think, and maybe you can expand on the intent, is to more transparency, not leaving homeowners in the lurch to not know what's going on. But I don't know that, I think we need more clarity as far as when that, who's responsible other than the association's board, and the timing of it. So I'm making sense.
Shrat Chandler, Administrator for the Real Estate Division. So I think you kind of summed up the intent there. So the intent really was, I think this came out of the legislative session because there was some language added to certain bills. And I don't think it really saw much daylight after because there were other controversial pieces in there. But really the idea was a lot of people were like, I didn't even know my management company changed, or I had no idea what happened. And now suddenly, I'm paying bills here. Now I'm suddenly doing this and I had no idea. So the goal was to get some information out to them, though, yes, there's notices. The incoming party sends notices and there's a transition. We understand all of that. But the concern was the timing of it, or when it happens and who does it. There was no real clarity on who informs these people, right? Whether it's the outgoing people, the incoming. And so some of the discussions during the legislative session was exactly that. If someone is terminated, there's no incentive or motivation for that management company to send something out, before they pack up and leave. And the new one is still saying, I'm still in transition. There's nothing. So maybe the onus needs to be on the HOA members or someone that's in a authoritative role there to send at least an email or a notice to homeowners that there is a transition. Now, the practical matter of this is 40 days, that's kind of the weed stuff, which is important to understand. So if there's a way for us to at least provide information to the homeowners through the association that there is a transition happening, that's all our intent was. The timing of it, who does it. We wanted to take it away from the outgoing management company, the incoming management company. We just wanted to put it on somebody in the association that's a responsible party during that transition to just give an email information to the homeowners. Now, the content of that email, what it says, the disclaimers, that's kind of something for each association to determine. But in our minds, a simple thing that there is a transition happening, be in the lookout for changes. So someone can come to us and say, you know what, they're doing this. I had no idea. And now I'm in this predicament where, I sent my checks here, that kind of stuff. So
Commissioner Herdern, what about within 10 days following a notice of either signing a new contract or termination with the current, whatever language there is, that within 10 days following that, they have to send a notice out?
The incoming management company, I think makes the most sense.
Well, they won't have records, so it would be that. And so here's the thing, the responsibility is on the board, but who's going to facilitate that? It's going to be the management company, right? It's the outgoing management company. If we say that it is required and you have to facilitate that. And I think for the most part, we haven't really seen really tough transitions a lot. I mean, I don't know what your experience is, Commissioner Gilliam, but
No, there
It's
is
just-
usually
sometimes there's a stop work, which is unfortunate and shouldn't be happening. But I think, within 10 days of, that you're going to be transitioning, to have the board through the management company send out an email blast. Hey, just so you know, we are transitioning management companies. Be on the lookout for
New
information
information.
from. I think that's reasonable because people get the notices and they put them in the trash anyway, right? And maybe they're more open to looking at email than waiting sometimes another 30 days to get a welcome letter.
I will tell you, Commissioner Gilliam, as a pattern of practice, the first thing when we're transitioning a association to our company, the first thing we do is say, hey, can we please have the roster? And we send out a actual letter saying, hello, we've been selected as your new management company effective this date. Here's how you pay your assessments, et cetera, et cetera. So that I can't imagine a scenario where that's not happening. So that's why I was saying incoming, because you need to do that to provide the adequate information.
Sure, Chandra, for the record. So we want all those practices to continue. So this is not to say, okay, now that it's in here, I don't need to do all of these other things. So the business world has to continue doing the best processes, whatever's out there. This is more from the homeowner's perspective, that we put something in regulation. And that's why we tried to leave the community manager out of it. I think it might have said community manager there, but that's really not the intent. The intent is the secretary or other officer specified in the bylaws, whoever's in charge at that time during the transition, sends out a notice. Now, that does not preclude all the other things that have to happen per the management agreement, the contracts. And this is something that, again, if it kind of sows more confusion, we don't want it to.
I just don't have the need for it.
Well, Commissioner Joe, I get that you're trying, I just don't see practicality how we're putting it on the secretary. Remember, this is a volunteer, the community you'd be able to go send out a letter. They're going to put it on the management company. That's where responsibility is going to lie there. I feel putting it on the secretary, whoever it is, the volunteer member of the.
They don't usually even have access to those records.
They even go and do it, because they even go and actually practically do it.
I just don't know, Commissioner Gilliam, I just don't know the need for this. If there truly is a need in the industry, then I'm happy to hear some examples. I just don't understand that.
People are complaining because I get my mail once a month if I'm lucky, right? So I don't see it. It's on us, not the management company. It's on the individual homeowners that aren't looking at their mail.
Point taken. Understood. I think those are all valid arguments for why we don't need it, but that was our intent. So, again, the secretary, this is not to bring disciplinary action against the secretary or the person in charge that they didn't send the email, right? The regulation is not in place to now bring this person to commission and saying, oh, by the way, 40 days ago, you did not send this thing per regulation, so now we're going to discipline you. That's not the intent. Now, if the secretary officer says, hey, management company, please do this for me, that's perfectly acceptable. So the intent was not punitive, like to bring disciplinary action against them. It's just informative. But if this adds more confusion, we don't.
Commissioner Hadarian, I could see a value in more communication is better than not. I think putting it on, most things are on the board members, right? and they delegate to management, I don't see a scenario that the secretary or other officer will be hitting the button on the email. A lot of times they don't have access to the roster. All that's delegated to management. There's always going to be folks, and to Commissioner Tibbetts' point, that don't ever open their mail but I think if there's an effort there, that's great. The only thing I can see conversely to not, bringing action is in a scenario where a homeowner now finds themselves in collections because they didn't get this email when they signed up for email. And then now they're challenging, well, you improperly changed management company. You didn't tell me. And so now all of your action that you've taken on this, I shouldn't be in collection. So I don't know. Yeah, I think the intent is there to communicate, but I don't know if this is the best way, unless we just want to say, hey, you know what, if you're changing management companies, in addition to a welcome letter from the new management company, you have to send out an email blast to everyone you have email with that this is forthcoming. Because a lot of times these are decisions that are made in a board meeting where no one attends, or they're not engaged in their association, so they have no idea what's going on.
Commissioner Gilliam, maybe I think you had said 10 days after notice of termination. Maybe that makes sense, that the outgoing management company has to send out the e-blast. I still don't, I agree, more communication is better, but I don't.
Commissioner Washington, even though this is the 26th year, 21st century, you still have people that don't have computers and don't have emails, particularly the older population. So to assume that you can send it out an email blast and everybody's going to get it is a false assumption. You need to send out a hard copy. If they don't open that mail, that's on them. But you can't just do an email and assume that everybody's going to get it, because then you open yourself up for liability. I don't have a computer. And it's your responsibility as the management company to make sure that I get the information. So I said that they have to send out a hard
And
copy.
Commissioner Herdarian, and typically Commissioner Gilliam can give her experience. If an association is leaving a company, the last thing they want to do is incur more costs with that company by mailing something out that now the new company will have to mail something out anyway, right? So we're adding that additional notice where they're not going to typically want to pay any more fees to this outgoing company, though they wait for the letter to come from the new company.
What's German? I think it needs to be defined who sends out what.
Yeah.
I don't get the whole company. Somebody needs to be in writing. It is A's responsibility.
I get that, but not right now. Yeah. Amy, are you able to is it Michelle? Have all the cards you have, you're done. I know. I don't know how you.
I'm not seeing who this is. Hold on.
No, it's a scroll through. Sorry. It was Michelle De Jesus.
Okay, yeah, I had muted, I think it was Sam Mozingo, but we're okay.
Okay, thank you.
Any further comments on this section? Section 14, I had a question. What is the need to clarify this language and expand on it? If you could just touch on that.
Chandra, Administrator for the Real Estate Division. So I think this is just to allow community managers adequate time to respond to certain things, unless it's an allegation that, the 12 working day requirement is very specific. And if it's not then the 12 days don't count. Essentially, that's really what it is. Because there's an expectation that you respond within 12 days for everything that's, requested. And this is just to say, if it's not specifically against a violation of 116A, you can respond. You don't have to do it within 12 days. That's just clarification for everybody.
Yeah.
Commissioner Gilliam, I can appreciate that. I mean, I'm sure get emails that are, not very specific in nature as to what their, issues are. That could be, I think clarifying this, that it has to be a specific allegation, with a statute referenced. Is that the intent here?
So, yeah, so if you look at the 116A 350, if a person alleges the community manager is guilty of misconduct, then they would have to send that and you have 12 days to respond.
Right, right.
And so if it's not specific to that and it's just generally a violation that they believe it is, then you don't have to follow the 12. Because we'll get a complaint that says this person never responded to me in 12 days. And so division take action and we're like, well, what exactly is it that's specific to that allegation? And if it's not specific, then allows the community manager time to respond to it and not hold them to the 12 days.
Um,
I'm sorry. Commissioner Tibbetts on section 15, unless we wanted to stay on 14.
I just have one comment, Commissioner Hadarian, on 14. So if this is more procedural, if the person making the allegations sends an email or a notice to the community manager that there's allegations that they've breached the law, and then they file their statement of fact, do they provide any sort of proof that they've attempted to contact the community manager and they failed to respond within 12 days? Or how do we close, how's that gap closed? Because like you said, with intervention affidavits, you don't want boards getting notices on something. I mean, if you're going to get a notice, you probably should know that it's coming or the subject of that. So as a manager, if they are supposed to receive that pre-notification from the complainant, like how is that verified on the complaint filing end? To verify, yes, they gave the person the opportunity to resolve before filing the statement of fact.
Sure, it's under administrative of the real estate division. And I don't want to talk too much into the compliance, but that procedure is built in. That is part of the investigation. That's the first couple of things that they check. Has this been noticed? Has there been a response? Has there been a good faith effort made to solve it? And then obviously part of the people complaining would be one of those that they didn't meet the 12-day requirement, and that's going to be looked at too. So it's all part of that process. But yeah, this is just so that when they do look at that, it's more clear that yes, was there a violation that was associated with 116A, and if not, then that time frame would not be required. So that's one less thing that they would have to look at.
Okay, thank you. Commissioner Tibbetts.
Yeah, Commissioner Tibbetts on section 15. Look at a couple of things addressing some of the public comments. I think if a board commissions a reserve study to be done, I think that's prudent that it be approved. So I think even if we're doing every 2 or 3 years, I think it's to the association's benefit to have reserve study if they're going to do it more often, that it should be approved and adopted. I also like the comment that was talked about tying it to, and the 210 days seems reasonable to me, but tying it to a budget, I'd be interested from a manager perspective. It seems like if we're going to do a reserve study, why wouldn't it tie into the current budget or the most updated budgets being done? So it seems like it should tie into a budget.
Commissioner Gilliam, I agree in theory that would be great, but it's also, I think, might put a lot of stress on the reserve studyists. If all of this, and most budgets are done year end, they're going to, could imagine, be overloaded with requests unless they set a hard line, like we must receive it 9 months in advance. I don't know. Functionally, I don't know how that would really play out. I agree that is a great practice, but I don't know how you work that into regulation.
Commissioner Hadarian, I'm assuming the 210 days mirrors the time frame to adopt a draft audit, so that we have that language already that within 210 days of them receiving the draft audit that they need to adopt that. They can't leave it open-ended. I like that we are putting a timeline on that maybe. because there was a couple of comments of the draft, if you can't narrow down the draft in 210 days, there's some things not, right? The boards can take meetings with the reserve study specialist, have a workshop, try to understand, make any changes. But it's already outdated. It's only current when it's issued. So I do concur with some of the comments from the specialists that 210 days, I mean, that's
Should be ample.
yeah, should be plenty of time. And then the requirement for the 609 form was within 45 days of the adoption of the draft. And I do agree, it needs to be in the minutes. Not all of a sudden we have this reserve study, but nowhere in the minutes does it state when it was adopted. And that should set the timeline for the 45 days for the 609 summary of reserve form that needs to go to the real estate commission. My only comments. Anyone else?
Mr. Chairman, I concur. I think you need to have a timeline. Period.
Transgender administrator, nothing, I think the discussion was pretty much what the 210 is the same thing, you're right, it ties to the audit too. The thing to try tie it to a budget, that's like, it adds too many layers. We don't want to do that in regulation, and now everyone's going to complain that those things, we want to leave some discretion to the boards to be able to adjust their timelines accordingly. Reserve studies are done 5 years. If someone does it in 2-3 years, that's great. But your budgets are done every year. So, if not this year, then you adopt it to the next year. So there has to be some flexibility built in. But having the board take some kind of an action on a reserve study is important, because that's really the issue that we've talked about earlier that keeps coming up, that, we need to maintain our associations, and then those reserves are off, and then what's the reserve study say? And then it says this, and then, it's that rabbit hole that everyone goes through. So we want to make sure that at least board is adopting it, and then it ties into the 45 days that they're required to submit to the division. So then we have it. So there's some kind of accountability along the way. That was the idea.
Commissioner Hadarian, so if the association is beyond the 210 days, what would the a proposed remedy be? I mean, how long are we going to let them go without them compelling them to get an updated study?
Hopefully it'll be a letter of instruction. And then if they don't act on the letter of instruction, we'll bring it to the commission. Okay. So that's the tie in there with the other piece that we talked about earlier. Why do we need that ability for the division to send out a letter of instruction? This would be probably a perfect scenario why we would do that. And then if they don't then do it, then we can come to the commission and say, hey, reserve study 210 was not adopted, sent a letter of instruction with detailed timelines of needs to be done, and they still didn't do it. And here we go.
Commissioner Gilliam, to your point, Commissioner Hadarian, at what point, I guess it's going to depend on the scenario, but at what point is a new study part of that letter of instruction, right? If it goes over a year, Mr. Forney spoke on it. If it extends too far, then it's no longer a current study and really shouldn't be adopted.
Anything further on 15? Okay, any final comments from the commissioners on any of the proposed?
Yeah, work to do.
Any final comments?
No comments. Thank you for your time, and thank you for all the public comments. And again, division is very grateful for all the feedback. The engaged population there's no substitute for that. So thank you.
So we can go ahead and close the public workshop.
Yes.
Okay, and let's go to lunch.
Damn.
Let's be back at 1:30. Okay. Yeah.
Okay, the chair is ready to call back in order. Carson City and Amy, please.
Carson City is ready.
Thank you.
Virtual is ready as well.
Thank you. Chair.
Okay, we are back. Thank you, everybody, for your patience. So we are moving on to item 4 on the agenda. For possible action, discussion, and decision regarding respondent Robert Stern's request for a waiver of stipulation and order for partial settlement of disciplinary action. And this was NRED versus Anthem Highlands Community Association, Robert Stern, Charles Hernandez, and Ronnie Young for possible action. The case numbers were 2015-3615, 2015-2155, 2015-3100, and 2015-2207.
Senior Deputy Attorney Crystal Keegan for the division.
Thank you. And is Mr. Stern present?
Amy, can you make sure that he's not online?
Yes. Do we have a first name on Mr. Stern?
Robert?
No, I do not have a Robert here.
Yeah, Chair, subject to that, in my review of the back materials, he said he was not going to be here and that it would just be enough downvote of the commission.
Okay, thank you.
Thank you.
Senior Deputy Attorney Crystal Keegan. So even though he's not here, I do have a brief response. And it just doesn't seem to be a priority for him, despite him asking extraordinary relief. We do expect petitioners to appear with requests like this for the commission. So legally, I just want to set the stage. NAC 116-617 does not prohibit oral argument in opposition or in response to a post-hearing motion, which I think that's what this is. And so I'm going to be proceeding and respectfully requesting the commission to allow me to make some brief points from the division's position, unless you feel comfortable proceeding on your own based on what he's submitted.
Please proceed.
Okay, thank you, Commissioner. So nowhere, I couldn't find in NRS 116 or NAC 116 the procedure for a waiver of a requirement ordered by the commission. So at best, I think this is a post-hearing motion requesting relief under NAC 116.6171C, which does require prior leave from the commission before it's even filed. I'm not sure if that's been complied with, and if it hasn't, that would be a basis to disregard it or strike it. But I'll just briefly proceed with my points. It's on the agenda, so I think we need to make a decision on it. Point number 1, a 10-year ban, that's typically reserved for serious violations. So vacating this ban early, our position is undermines that. The second point I wanted to make is that it's not sought within a reasonable time. He's literally asking for this at the very end of a long-term ban. The 10-year ban expires June 16th, 2026. That's in 3 months. It's close to expiration. He hasn't demonstrated any exceptional circumstances other than the passage of time or his desire to run for the board. So his request serves his interest, not the public's. He hasn't presented any evidence that exonerates him. In fact, his January 15, 2026 statement to the commission, which you have in your packet, knowingly admits he is actively running for his board since January of 2026, which our position is, yes, that violates the spirit and intent of the ordered ban, because the whole purpose of running is to take a seat. And he's legally barred from doing so and taking the seat for a term that would begin on May 1st. So there appears to be an attempt to reach the commission. And third, my last point, which I started with, Mr. Stern is not here, and that completely deprives this commission with any opportunity to ask questions and verify his claims, and arguably because it wouldn't withstand your direct questioning. So our position is that the commission's order should stand. The 10-year ban from serving should run its full length through the 3 months left, and the petition should be denied. Thank you.
Commissioners, any questions?
I would just make a comment. Like Ms. Keegan said, I wasn't sure what the motion was brought under, and I would think, based on that he would be a very active board member participant based on the flyer he submitted into evidence. I'm not sure why he wouldn't come here today to discuss that. I think that the language of the agreement is exceedingly clear that he agreed that it would be when it was dated. I also do get the reality, hey, we're only a few months away. But it doesn't seem like it'll impact their elections or their ability to fill the board. So I'll submit on that. I'm tending to very much agree with the department on this.
Commissioner Morse-Jarman, I have a question. Suppose he runs for the board and wins and sits on the board, then what do we?
I mean, Commissioner Haydarian, he would be in violation of the
Well, if he
order.
doesn't even show up to defend his request for petition to waive the 3 months, what makes you think he'll show up if he's in violation down the road? Because I'm assuming that he's bold enough to send us a flyer saying that he's running, that he pretty much thinks he's got it in the bag. And I was prepared to ask him about his sense of entitlement. Because he sent us a statement, to Miss Merriweather about. I'm speechless.
Commissioner Sweeten, again, for the record, I just would echo every single thing Commissioner Morse-Jarman just said.
Are we ready for a motion?
I would move to deny unless council or the department has a different, I would call it the special request for waiver that was submitted by the petitioner, and that would be the motion.
I second.
Any discussion? All those in favor, please say aye.
Aye.
Any opposed? Okay. All right, that takes us to the next item on the agenda. In the discussion and possible action by the commission, NRED versus Sierra Ranchos Property Owners Association. This is in reference to case number 20181663. I believe they are here for a status update.
They are. Thank you very much. For the record, Phil Sue, Senior Deputy Attorney General of the Attorney General's Office, on behalf of the division. And I believe Mr. Lauren Pierce, President, Sierra Ranchos, is online as well.
I'm here. Lauren's here.
Thank you. Commissioners, as you're aware, about a year ago, you all heard the last status update on this matter, issued an order asking that the association provide some kind of status update regarding its ongoing road construction project. And if it was able to provide documentation to your satisfaction, then this matter would be taken off the calendar. But they were unable to. I think instead you have a letter from Mr. Pierce that he provided yesterday regarding the circumstances that the association is undergoing, that they have continued with the construction project, including the allowances that their providers have given them, special terms of contract, but they themselves have had issues with collection of the special assessments necessary to complete the project. At this point, I believe the letter stated there was a shortfall of about $75,000 in collection, and that they're taking two potential courses of action to try to remedy that situation. First, they were going to seek assistance through the Bureau of Land Management for financial assistance for 9 miles of the association's roads that are access to public access roads and that have to be maintained for that access. They also have a ballot initiative that may or may not receive this required support from membership to try to seek relief from district court. At any rate, there are certain challenges that they're facing right now with meeting the full terms of the commission's order, that is to complete the project. And I don't know if there's anything else, Mr. Pierce, that you wanted to let the commissioners know, or if you want to clarify anything that I stated on.
Thank you, Mr. Sue. Good morning or good afternoon, Commission. Yeah, so the letter I presented, I didn't think I was going to be able to make it today, but I was able to at the last minute. So where we're standing at on the board is we've done 2 ballot send outs to the association from to get the number of votes needed to change our bylaws. Because of the way our bylaws are written, it takes over 18 months before we can send anybody to collections. And we've been trying to get that changed, and we can't get enough respondents back on the ballots. So we're doing our 3rd ballot send out to see how many more we get back. And if we don't meet that number, then the board has approved to go ahead and proceed with the bylaws going to district court and asking for a judge to amend our bylaws so that we are in compliance with NRS, so that we don't have to wait a year and a half to start collection action, and we can do the 6 months as per NRS 116. And that's kind of our holdup. People know they won't pay, and then they'll wait to go to collections and then suddenly pay. However, we still have to pay the creditors. So, but the work that initially for the stipulation order is all being completed. Payments are being made to the contractor. He's happy. We would just like to hurry up and get that paid off so that we can move on with other items. We are seeking, we have a grant writer that is working for or with us at no charge, an experienced grant writer, and we're presenting that to the Bureau of Land Management, requesting assistance from them, means we have to maintain roads for open space access to the BLM. It was our understanding also that the Bureau did come to the board several years ago and offer help, but for whatever reason, that board that was in place refused their help, which didn't make any sense to us. So now we're going back again and trying to reopen those discussions with them and get funding. And that would certainly help us to a tune of a couple $100,000 if they agree to do that.
Okay. Thank you, Mr. Pierce. Commissioners, any questions?
I have a question. Madam Chair, Commissioner Moore-Starman, sir, when is your 3rd and final ballot going to be sent out?
Hopefully this month. I've got to talk with our property management and make sure that they are getting that out this month. We just voted on it earlier, or excuse me, at the middle part of February, so it should be going out real soon. I don't have an exact date, but it should be in March.
And how much time after the ballots are mailed out do you allow for them to return?
That's a question I would have to ask Equus. I believe it's 30 days.
All right, thank you.
Don't have any questions.
I believe at this point, it's to you all as the commissioners to decide what would be the next step for Sierra Ranchos for this case as well. If you require additional follow-up from the association, additional information, or because it appears that Mr. Pierce, work has been done, but payments are still coming in, or they're still trying to collect the payments to finalize them. So I suppose it's probably more of a commission discussion.
Commissioner Hudarian, for the record, looks like they have an uphill battle here with the bylaw amendment if they're going to try to also seek relief from district court to amend the bylaws. I am okay if we hear back from them. Let's just ask a date in the year. Yeah, I'm not really sure how much more, or if any help that we can provide to them. Sounds like they're on the right track.
I agree with that.
If I may, Phil, for the record, based on the terms of my prior order, I think maybe you could just reuse that and push dates out and request a status update. If they provide documents to our satisfaction, then take it off the calendar. But otherwise, let us know what's.
So at the next. commission.
Next March, next commissioner, so depends on, yeah, I suppose the ballot initiative is gonna be resolved by June. And should be able to clarify if that's the case, then maybe it would be helpful to know that and then decide then if we want to have set the subsequent status check out further. Because litigation does take a while to kind of make its way, so at that point, having them come back every quarter isn't very.
This is Commissioner Tibbetts. I mean, I would be all right, just like even waiting 9 months from now or even a year from now. It seems like they're on top of it. It's like we're working through it. They have their challenges. I don't think we need an updated 3 months, but if we wait 9 or 12 months,
So I believe Commissioner Darian, what Mr. Sue is indicating that we need to stay with the current order that's in place, which would require,
Sorry, not,
we should.
just that it would be a template for any kind of order we would. want.
Oh, I gotcha. I'm sorry.
Oh, that's there.
Mr. Gilliam, I would agree. I think a 9 or 12 months check, status check makes sense.
Commissioner Sherman, I was going to suggest that they give us a review of what happened from the election results in June, but based on what the attorney said, I'm good with a year. By then, we should have a conclusive analogy of what's going on. Hopefully.
so I'll make a motion for a status check in a year from now on this order.
Mr. Gilliam, I'll second.
Okay, any discussion further?
I would just like to thank everybody. I'd like to thank the commission for the guidance you've given to the SRPOA over the last few years since this stipulation order initially came out. It's really helped us move forward and get this association back on track. Without it, people wouldn't have been doing anything. So thank you.
So Commissioner Haydarian, with that status check, just an update on the status of the actual repairs and then any additional information they're able to provide on the status of any collections or if they were able to get ELM assistance.
Need a vote?
Did you want to?
I'm okay. I have no comment.
Okay. All right. All in favor, please say aye.
Aye.
Any opposed? Okay. Thank you.
Thank you.
Thank you, everyone.
I'm sorry, we
you.
missed the second. I second. Okay. Thank you.
Okay, so we are now on 5B. Are we doing B and C together?
We are.
Okay, 5B and C, which is NRED versus Amy Moore. Case numbers 2025-149, 2025-503, and 2025-811. We do have one preliminary matter.
Yeah. The Commissioner Tibbetts, I have a business relationship with the respondent, so I need to recuse myself from these matters.
Thank you. Is Ms. Moore present?
Yes, I am here.
Okay. I'm going to swear her in now. Ms. Moore, I'm going to go ahead and swear you in. Can you please raise your right hand? Do you solemnly swear or affirm that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
You, Division Counsel?
Thank you very much. Phil Stu, on behalf of the division. So in these both consolidated 149 and 503 matters, as well as the 811 matter, the parties have agreed to stipulate to the facts that as alleged, as well as the violations as alleged in these cases. So that being the case, division and Ms. Moore present this matter not so much to prove the case, because it would have been proven based on the allegations the division contends, but instead to seek the commission's determination as to discipline. That being the case, I rather than having a presentation of witnesses, my plan was to go ahead and request that I'd be offered the opportunity to read the facts into the record, both for everybody's edification, as well as to provide you all with an opportunity to review some of the pertinent documents while I am kind of going over this underlying facts.
Okay, you proceed.
I guess first step first. I'd like to request that the division's documents in both cases be admitted into the record. Believe that they are in your respective folders under the do not open. Just for the record, let me. Lost my ritual work. For case number 2025-149 and 2025-503, I am requesting that CICCH 0001 through 0061 be admitted into evidence.
Ms. Moore, do you object to moving these documents into evidence?
No, I don't.
Okay, so moved.
Thank you. And then for 2025-503, I am requesting that documents CICCH 0062 through 85 also be admitted.
Okay, same question, Ms. Moore. Do you have any objections to moving these into record?
No, I don't.
Okay, so moved.
Okay, and with that, I will go ahead and recite the facts for cases. So for the consolidated cases 2025-149 and 2025-503. Respondent Amy M. Moore has been licensed as a temporary community manager, and or a supervising community manager in Nevada since July of 2019. At all times relevant herein, respondent held a supervising community manager certificate issued by the division CAM.0009792-SCPR and served as supervising community manager with Vintage Real Estate Group. At all times relevant herein, the respondent served as the supervising community manager for Cielo Vista Community Association and Majestic Point Community Association. Investigation case number 2025-149 was initiated by the division's compliance division based on documentation from the Secretary of State's website reflecting that respondent is currently serving as a member of Cielo Vista's executive board while simultaneously providing services as a community manager. Factual allegations regarding case number 2025-149. On March 5th, 2025, the division issued a request for information letter regarding Secretary of State's documentation, as well as meeting minutes, financial statements, bank statements, and the most current reserve study. A second RFI request was issued on April 1st, 2025. On April 14th of 2025, Colleen Rosen, Director of Operations for Vintage Group, responded to the request for information with the annual association registration, showing that the respondent was not an executive board member, but serves as manager for Cielo. On the following day, the division responded via email that the requested records still needed to be provided to the division. On May 29th of 2025, the division emailed Rosen again, noting that the documents have not yet been provided. A third RFI request was issued on June 4th of 2025. The fourth and final RFI request was issued on June 17th of 2025. On June 20th of 2025, CAM William Newborn sent an email to the division, again noting that respondent was not a Cielo Vista board member, but served as manager for Cielo Vista. On June 25th of 2025, the division sent yet another written request for the records and documentation indicated in the preceding RFIs. On June 30th of 2025, respondent provided the requested documents in her possession, including financial records from January 2024 through February of 2025. Financial records provided by respondent included a total of 19 check stubs for checks 1002, 100022, 100025, and 10027 through 10038, showing payments made to Brightview Landscaping Services, Inc., CAIS, LLC, LeVar Oskme Insurance, Newman and Associates, Complex Solutions Limited, and NRED, and for checks 1037 through 1039, showing payments to Gulf Equities, LLC, Orville, Garrett, Arita, and Danny or Lenabelle Reynolds. Check stubs were dual signed by respondent and by a person identified by the respondent as Vintage Group's Director of Operations, not by any of Cielo Vista's executive board members. On July 7th of 2025, the division sent RFI letters to Cielo Vista executive board members Manuel Reinaga, Wayne Johnson, and Iris Flores, inquiring as to how board meetings were held, how the annual budget was approved, how checks were approved and signed, how elections were held, and how often the board reviewed the association financials. On July 16th of 2025, board member Reinaga sent this response to the division noting, among other things, that 3, we haven't had to sign invoices or checks recently as there have been no reserve expenses. Payments are set up via autopay. Also on July 16th of 2025, board member Johnson responded to the division noting, the invoices are on autopay with strong room. There are digital signatures. We have not had any reserve expenses that require 2 board member signatures thus far. On September 25th of 2025, the division sent an additional RFI letter to respondent regarding her permitting an individual who is neither a Nevada certified community manager, a duly elected board member, nor an officer of the association to sign association checks from at least September 2021 through March of 2025. On October 1st of 2025, respondents sent a reply letter indicating that the checks from Cielo Vista's operating account were signed by herself as community manager and by Vintage Group's Director of Operations, which was, quote, an error that we have corrected. Unfortunately, it was a setting in our system that applied to communities outside of Nevada. On October 6th of 2025, the division sent respondents an NRS 233B letter indicating that through its investigation, it obtained sufficient evidence to commence disciplinary action by filing a complaint for disciplinary action before the commission. This next section is factual allegation regarding case number 2025-503. On July 24th of 2025, the division issued a request for information letter regarding her permitting an individual to sign Majestic Point Association check number 10005 dated August 26th of 2024, who was neither a Nevada certified community manager, a duly elected board member, nor an officer of Majestic Point. The RFI requested copies of bank statements, financial statements, and meeting minutes from 2024 through to present, and the most recent research study. On July 28th of 2025, respondents sent a reply letter indicating that operating check 10,005 was signed by myself, the community manager, and our operations manager, and noting that we have modified operating checks to only be signed by the board of directors and included financial statements for the requested time frame. The 12 check stubs included in those financial records showed payments made to Sun State Companies LLC and NREC. Check stubs were dual signed by respondent and by Vintage Group's operation manager, not by any Majestic Point's executive board members. On September 23rd of 2025, the division sent respondent an NRS 233B letter indicating that through its investigation, it obtained sufficient evidence to commence disciplinary action by filing a complaint for disciplinary action before the commission. There are 4 violations of law in this complaint. They read as follows. Respondent violated NRS 116A.630 subsection 1B pursuant to NAC 116A.55 by failing to exercise ordinary and reasonable care in the performance of her duties when respondent repeatedly allowed checks to be drawn on at least 19 occasions from the operating account for Cielo Vista with signature of Vintage Group's operation manager / director of operations, who was neither a duly elected board member nor an officer of Cielo Vista. Second violation reads, respondent violated NRS 116.31153 subsection 2 pursuant to NAC 116A.3552 and performed acts of unprofessional conduct by repeatedly allowing checks to be drawn on at least 19 occasions from the operating account for Cielo Vista with the signature of Vintage Group operation manager / director of operations, who was neither a duly elected board member nor an officer of Cielo Vista. Third, respondent violated NRS 116A.630 subsection 1B pursuant to NAC 116A.325 by failing to exercise ordinary and reasonable care in the performance of her duties when respondent repeatedly allowed checks to be drawn on at least 12 occasions from the operating account for Majestic Point with the signature of Vintage Group's operations manager, director of operations, who was neither a duly elected board member or an officer of Majestic Point. And the final violation pertains to NRS 116.31153 pursuant to NAC 116A.355 subsection 2 that she performed acts of unprofessional conduct by repeatedly allowing checks to be drawn on at least 12 occasions from the operating account for Majestic Point with the signature of Vintage Group's operation manager or director of operations, who was neither a duly elected board member or officer of Majestic. So that is the first complaint. Second complaint. Fortunately, it's shorter, but similar facts. The factual allegation that in 2025-811. Respondent Amy Moore has been licensed as a temporary community manager, and or supervising community manager in Nevada since July of 2019. At all times relevant, respondent held a supervising community manager certificate issued by the division and served as supervising community manager with Vintage Group's real estate. At all times relevant, respondent served as supervising community manager for Juniper Trails Community Association. Investigation case number 2025-811 was initiated by the division's compliance division based on association check number 100030 that dated April 23rd of 2025, which appears to have been signed by an individual who was neither a Nevada certified community manager, duly elected board member, nor an officer of the association. On October 9th of 2025, the division issued a request for information letter regarding the allegation that respondent allowed an individual who was neither a community manager, a duly elected board member, or an officer to sign checks on behalf of Juniper Trails, including but not limited to association check number 1030 dated 4/23/25. On October 17th of 2025, respondent provided her response, including documents requested in the RFI, and stated that Vintage strives to comply with all NRS statutes and guidelines. We apologize for any failures and have implemented a change in policies and procedures internally to prevent any errors in the future. Among the documents provided by respondent are copies of 39 checks dated from January 9th, 2025 to August 13th, 2025 that were auto-signed in similar fashion to Association Check 100030. On November 12th, 2025, the division sent respondent an NRS 233B letter indicating that through its investigation, it obtained sufficient evidence to commence disciplinary action. The violations of law for these two mirror the other ones. So for the sake of time, I'll just note that the relevant statutes are NRS 116.31153 pursuant to NAC 116A.355 subsection 1A for the first violation. And the second one is NRS 116A.630 subsection 1B pursuant to NAC 116A.355 subsection 1.
Thank you very much.
So now I ask.
Yeah, she wants to, are you had said earlier you might be stipulating to some.
I believe I definitely want Ms. Moore to confirm, but it's my understanding that we are going to be stipulating to all the facts and the violations as alleged.
So,
Yes, that's correct. Yes.
so, she's not providing a response at this point because they're stipulating that everything stated, they're agreeing that everything Phil just stated is correct.
Okay.
I think the question then would be.
I guess before we.
You stipulated to I guess.
Not yet, we haven't stipulated yet to potential discipline. Instead, the division was going to offer its own recommendation.
Okay.
I guess before we even get to that point, am I correct in the understanding that Ms. Moore's filed answer is already part of the record?
Yes.
Okay.
So you could get a recommendation and then let her give a response to his recommendation regarding discipline. And then you guys can ask questions, deliberate, or I guess before you get to that, they've stipulated to violations. You don't really need to make a finding, or you can. I don't know if we need a motion, though. If you'd like one, we can get a motion to find the violations, though they have stipulated that there are violations. But for the discipline portion, Mr. Sue will make a recommendation, and then Ms. Moore can give her response to that, and you guys then get to decide what discipline.
Ask questions, and then we can.
Correct. So if you have any questions though regarding the violations themselves, now might be a good time for that. I mean, they're agreeing that there are violations, but if there's any questions or maybe you don't want to find some, I guess now would be the time to ask those questions.
So commissioners, any questions?
I have a question. Commissioner Moore-Starman, Ms. Moore, are you currently employed as a CAM?
I am the owner of Vintage Group. So, and yes, I am.
So you currently hold the license?
Yes, ma'am, I do.
Okay, thank you.
Any other questions? None? No? Okay, then we'll proceed with the division's recommendation for discipline.
Yes, some preparatory. Remarks. So, as I noted in the complaint, she's held a temporary certificate, which essentially is something that somebody who's practiced as a CAM in another state can obtain that temporary certificate here for a year. But it doesn't necessarily include supervision that provisional CAM. She's held a temporary certificate as well as a standard CAM certificate and currently supervising. Division's recommendation reflects the fact that she never has been supervised by another Nevada CAM, and there appears to be some disconnect between her experience as a CAM in California and here in Nevada. I think one of her responses to the division noted that in her December 1st, 2025 letter, initial response to the first consolidated set of cases, she noted, learning NRS through initial and continuing education has been a challenging process. Her wish and desire to remain compliant with NRS guidelines and that they will continue improving with education and professional practice. In light of that, the division's recommendation is $500 administrative fine per charge. There being 6 charges. The division's costs and attorney's fees, which Ms. Gallo testified to, and that Ms. Moore's supervising CAM license certificate be downgraded to a provisional CAM license for a period of 2 years, so that she can receive that supervision from another supervising CAM who is very familiar with Nevada law and can assist her with continue to maintain compliance.
Okay, thank you.
So giving us more of the opportunity to.
Ms. Moore, do you have a response?
Well, first of all, I would like to apologize for adding this agenda item to your already packed session. Obviously, I do not deny any of the allegations or violations that were brought forth. And as mentioned before, it's definitely been a learning curve, even though I've been a manager and in business for over 12 years with an extensive amount of experience outside of Nevada. And we strive to do the best job for all of our clients. And unfortunately, in today's technology, some of our platforms, they do things so well and automated for us. So unfortunately, this is how the dual signatures did occur. Also, the additional person who was signing, our director of operations, has also become a CAM since all of this has occurred. And we are constantly doing additional education every chance possible to keep up with our licenses and to continue learning as much of NRS as possible. I mean, it's obviously an extremely large statute and it takes many years and a lot of time. Well, I'm sure nobody ever has it perfected because I'm sure it's always changing as well, but we are doing our best to stay on top of it. The initial education in obtaining the CAM, is long and extensive, as you know, and but the daily and ongoing education is much more important for retention. And it's definitely a thankless job, and there's not a lot of us out there to do this job, and but there are many positives to it and people who make it worth doing it. So I'm, certainly honored to be licensed and to be able to practice in Nevada, and I would ask to be able to continue to do so. While I understand the recommendations, I would ask for any leniency so that I can continue conducting business in the state, being that I am the supervisory CAM for my company. And I think I didn't hear exactly correctly. I just want to make sure I understood. It was 500, 500 per violation times 16. Is that correct?
Times six, two
Oh,
violations.
oh, okay. I'm sorry. Yeah, I couldn't hear you. I'm sorry. Yes. And I understand and would completely agree to that.
Okay, Commissioner Hadarian for the record. Ms. Moore, did you take the 60-hour pre-licensing certification course at all?
Yes, I sure did. Yes. At at the university.
UNLV, okay.
Yes. And it's been a while. I mean, it was during COVID. No, it wasn't. It might have been during COVID. Yeah, it was quite a while ago. So.
Thank you.
Mr. Morris Jarman, point of clarification, Ms. Moore, the checks that you wrote, these multiple checks, they were for business conducted within your community, not for personal use. Is that correct?
Absolutely. Yes, they were for contracted items for the association. So, you know, and I hate comparing anything to California. It's embarrassing, but yes, normally we conduct and are able to execute operational checks for contracted items. And so that's how our system has been set up. Whereas now, of course, Nevada, we only have board members. Reserve checks have always been to board members, even out of state. But we haven't had any reserve items as mentioned.
Thank you.
Anything further, Mr. Suter? Oh,
Yeah, I just came up with a question. No, you're good, Chair. Commissioner Sweeten here. Ms. Moore, you referenced that this department's recommendation was to downgrade your supervisory CAM license to a provisional CAM for 2 years. You also mentioned in your comments that someone else, your deputy director, I believe you said, has now been licensed as a CAM. What impact on your ability to make a living or your operations would a provisional downgrade have for 2 years?
Well, I believe it's an NRS requirement that you have a supervisory CAM within your organization. And being that I am that would eliminate the ability to service our clients in its entirety.
Thank you, Ms. Moore. One other question. Have you ever been penalized in California or any of the other states you've done business in?
No, and I am also a broker in California as well, but I have not.
Thank you. That's all I have.
If I may be heard, Phil Super record. Procedurally speaking, these types of downgrades, they occur in other licensing contexts, primarily real estate. I've spoken to division staff and will note that there are supervisors and CAMs who will operate within their own brokerage, but then will also on the side be able to provide those supervisory services to people such as those in if the recommendation is taken in tomorrow's jurisdiction. So,
sorry, Mr. C. I didn't mean to cut you off there. It'd be like you contract with a supervisory CAM from somewhere else to just watch your work.
That's my understanding.
Okay.
So it wouldn't necessarily eliminate her ability to perform this type of work, but it would be an additional step that would ensure supervision's occurred.
Thank you.
any further questions? Ms. Gallo, is this the appropriate time to ask for the division's fees and costs?
Yep, I have it. Sorry. Yeah, it's for me.
Oh, please raise your right hand. Do you solemnly swear or affirm that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
And since we're combining these,
We are.
so just one total from,
Yeah, that probably would be best for the sake of our order. Sorry.
no, I have it. I just wanted to make sure if you wanted it broken down.
Grand total, please.
Got that. So for in the case, Amy Moore, 2025-149 and 2025-503. And her other case, Amy Moore, 2025-811. The division's fees and costs are in the amount of $6,000 $442.87. And those fees are reasonable, necessary, and actual.
Okay, thank you very much. So now we will open it up for discussion amongst the commissioners.
Yes. She's correct.
Commissioner Gilliam, for the record, I think that, given that this is Ms. Moore's first, set of action taken against her and violations, I personally think that the downgrade to the provisional is a little steep. She did go through the 60-hour course. So that would just be my suggestion, is that's removed from the action, but just my own thoughts there.
Wait, sorry, just give.
Commissioner Hudarian, I did notice that one of the potential penalties is to place the community manager on probation. Have we ever done that before? What does that look like? What are the terms of the probation? Does anyone can offer insight into that?
I had not myself dealt with that, but my understanding when it comes to licensing probation type situations, say in the dental context, which is where I was previously, some sort of monitoring, perhaps by some appointed other licensee, and the licensee would report to them for a set period of time. But I'm sorry, but Rosalie,
I can speak generally in licensing context, although this doesn't fall under Title 54, which is where all of our other licensing contexts are. It could be almost any conditions you want to place. The probationary term is kind of a flag on the license and allows you to place conditions. When you see it in medical, dental, those types of, sometimes you see it as just a status that it is probationary, such that you can ask for status checks when you see it when it has to do with, substance abuse in medical professions, right? It'll be probationary because that's the only way they can put the tag on to say you have to remain in a program, right? And then because without calling it probationary, there's no way to put requirements. So you could also just call it probationary and say, we're calling it that so that for a period of 2 years or whatever the period is, if some other violation were to come up, it's going to be taken far more severely because you are on probation. So you could make it as simple as that, or you could require some amount of reporting. It really can be almost whatever conditions you guys want to place. Precedent wise, that would be a question. I don't know if you guys have dealt with that, or if it's dealt with in the real estate sense, which does fall under Title. If you have any precedent there, but that's where we see it with other licensing and licensing boards usually is it really varies depending on what you feel would get to the public protection aspect here, get you to that compliance aspect you're looking for.
Okay, thank you.
Commissioner Sweeten, I obviously defer to the expert cams that are on the board. I think that's why they're here. I would say, as a potential option here, I tended to agree with Commissioner Gilliam initially that the downgrade seems steep given the first offense in other states. I don't know what the feasibility is of retaking the 60-hour class or doing something like that as an option instead of a downgrade. The probation seems to be, though, a more feasible option. I was going to mention retaking the class or doing some amount of continuing education courses, or I don't even know if you can retake the community manager exam. You can? Something like that. It is, I would submit, I think Ms. Moore's recognized that NRS 116 is somewhat complicated. And so, doing a little extra practice in Nevada may remedy it, some combination of any of those. That's all I have.
Commissioner Moore-Starman, I'm in agreement. I think that the downgrade is a little steep. That almost prohibits her from performing in full capacity, if you will. I'm more in favor of a probation with stipulations that should be supervised and that there be some type of reporting period, reporting stipulations back to us about her progress and make sure that she does not violate any other sections of 160.
Commissioner Hayden, for the record, I do also recognize maybe down to a provisional may not be the best. I do like the idea of potentially having to retake the 60 hours. There's a lot of information in the 60 hours, and the not signing checks is a basic thing for community managers. We say it, you know, I don't know how many times in the pre-licensing. Everyone knows that. It's something that should be taken seriously. Luckily, these were just checks to service providers, but I don't think we should excuse the fact that this happened repeatedly. And I also want to mention, in the state of Nevada, when the real estate division asks for records, it shouldn't take 2 and 3 times and 4 times to turn over records. So just to be mindful of that. I mean, this started in 2025 and we're hearing it in 2026. So if we can agree on some sort of probation, the other concern is she, currently is a supervising CAM with a brand new provisional under her. And how are we confident that that person's going to receive the level of supervision and training that provisional manager should receive from their super CAM? It's a lot, right? So I don't know what the answer is to, yes, allow the continual management, but also ensure that just some of the basic things that one would pick up through being a provisional for 2 years under a super CAM is absorbed and able to be passed on to other incoming managers under a super CAM's license.
Commissioner Sweeten here, probably a question for Mr. Sue or Ms. Boardlove. I don't know how creative we can get with these settlement or what we impose. And I know that we do have some level of latitude, but something along the lines of, that, whether she retakes the 60 classes and gets to continue doing what she does, whether there's a probation or hey, you got to work with another supervising CAM and report back quarterly for a year or something. And then, hey, if you fail to meet any of these requirements, we hold the right to bring you back and reduce you to a provisional. So then there's some level of motivation there to do it, make sure it's done. And if it's not, then I think I understand Commissioner Hayder, I think what you're saying. I mean, there's some level of risk here where you have a supervisory CAM relatively new to the state. This apparently is a big deal and is well known. And if someone else is being supervised in that context, another point of contact may not hurt and maybe something to make sure that it's happening.
So if it's a board, Rosalie Bordelot for the record, if this is done via board order, so you're saying you're on probation, but we need to see these things. Then it needs to be really clear, I guess, what that is. To the extent there's a requirement to have a supervisory CAM, I would suggest giving some time frame because this is not something she already has in the process. She's going to need to find one willing to contract. It's probably going to cost something that isn't prohibitive of you doing it. In addition, anything if she's making reporting or others, very clear guidance to whoever she's reporting to, what they're looking for, whether there's a status check back. And sometimes the way that looks is you're saying it's probation with this. Sometimes it's saying, okay, we're going to call it a down. We're going to say what we frequently see is, a stayed revocation, right? Pending completion of these things. And if you complete them all, then within a certain time period, then the order is fulfilled and your license is never actually revoked. So this would be maybe a stayed downgrade or whatever it is, but you need to complete these things within a certain period of time. In which case we'll consider it taken care of and it's never downgraded. That might be an easier way to go. You could hear from her if that's a possibility of something she can do. Another option would be to send her Phil off to go see if they can come to some agreement and bring it back to you guys.
Okay.
Before we
go ahead.
Before we do that, Pilsley for the record, Just a couple of clarification points. I don't believe that Ms. Moore has any provisional cams under her supervision. She has a actual cam.
Oh, okay.
That is her colleague. But she is the supervising cam of that, of her organization.
Oh, this is Commissioner Darian. It seemed that someone is a cam now, just got their license. So is that,
According to SOAR, no. Maria Gallo for the record. According to division record, she has no provisionals under.
okay.
Just
guess
a
that's-
temporary.
That the temporary is still on their own.
Yes.
They're licensed to run their own company, their own communities.
And that's why I noted in my original complaint, she only had been a temporary and then a candidate. She's never had that provision.
Commissioner Morse Sherman, Ms. Moore, is it feasible that you be able to find within a reasonable period of time another supervising cam to supervise you? Is that feasible?
Well,
we-
I mean, it's a great question. I'm actively in the recruitment process of one outside of, going to a competitor as a supervisory cam and asking for one to supervise. Unfortunately, my success rate with those people that I have employed in the past did not turn out so much in our favor. So I'm very cautious and during the process of finding, the right person for the company. And, it takes some time, like you said, but I am actively recruiting for one.
Follow up, Morse Sherman. My concern is that we're not looking at October and she still hasn't found a supervising camp to supervise her. So how do we remedy that? Either we eliminate that phase of it and come up with some other solution, or give her a very restricted period of time to complete that, whether it's a competitor or not. I don't know what that process is. That's your view. But I don't want to put something in writing and she can't possibly fulfill it.
Commissioner Darian for the record, perhaps the provisional is not the step, maybe full cam instead of supervisory for a certain period, pending whatever educational requirement or additional training. So that when she becomes a super cam again, she's had adequate experience in this state to be able to fully train another camp. Because right now, as it stands, there's another temp licensee, right? It's not a provisional, doesn't have a super camp, it's not, right? I mean.
Yeah.
So maybe that's.
I could support that. Makes sense.
So that somewhat eliminates the having to find a supervisory cam.
Yeah, because you'd
It's like
still,
a can of worms that
Yeah.
may not be able to.
yeah, I think the same thing. but-
Challenging.
Yeah.
Um,
So if you were to go to a camp status, asking you guys this, if you were to go to camp status, you could still, wouldn't
Yes.
impact her job. And then she would have educational requirements, or something like that. And then when that's complete, in theory, she could reapply to become a super cam again. Okay.
Okay.
Commissioner Gilliam, just on a timing standpoint, we are talking about the 60-hour course that's only offered 2 times a year, and it's currently in play right now, right? So,
UNLV already has dates published for summer and fall.
okay,
2 more offerings, and then I believe P is still offering.
okay.
For 3.
So there are options out there. But just, it will take a little bit of time, just so, keeping that in mind when we're talking time.
Here, so maybe a year.
Yeah.
That's more feasible.
Okay, is there a motion?
Happy.
Yeah, I'll try to make it. I wrote down the amounts Maria read us. All right, here we go. All right, Commissioner Sweeten, for the record, I would move that in dockets 2025-149, 2025-503, and 2025-811, that we accept the facts as stipulated by the parties, that we impose a $500 fine for the 6 violations, that that fees and costs in the amount of $6,400 $442.87 be required that defendant pay that amount. And then that the license, the defendant's, sorry, we're not defendants here, right? Respondent's license, sorry. Respondent's license would be downgraded to a CAM license, and that she would have 1 year to complete the 60-hour course and show proof of completion to the commission. I would further move that upon proof of completion of that course, that she'd be eligible to have her case closed out here.
Was there a timeframe for payment?
Time frame for payment.
And the finding of the violations.
Oh, I did. I put that at the
You said
beginning.
facts.
Yeah. Oh, sorry. Finding of the violations. Thank you. So I would also move that we accept the violations as stipulated, and that she would have 90 days to pay. Is that all? 90 days? Okay.
I don't know, is she able to? Great.
Well, so Bill Super record. I just wanted a point of clarification because I'm going to be drafting this order. I have it here. 1 year to complete the 60-hour course, provide proof of completion. I understand that to be to the division, but.
Correct, to the division.
And then eligible for her case to be closed out. So no requirement for her to appear before the commission again. Once she's submitted that to the division satisfaction, then we can go ahead and process an application for super again.
That's fine with me unless for efficiency purposes, someone wants to correct that motion. I'm happy to change it. Okay, that's fine with me.
Is that what we're just,
Okay.
okay. Thank you.
I guess to clarify, just so you don't set her up, 90 days, is that seem reason?
For payment.
Yeah. Yes. Okay.
Question. What's Jarman, is the 90 days to pay the total 12,000 plus change? Okay. One or two.
It was 9,000, I think.
Well, I thought it was $6,000 fine. It's
No,
500
500
times six.
Times 6.
Yeah, 500.
That's 3,000.
3,000.
Yeah, you're right. I'm right. I'm sorry. Fuzzy math.
May I ask a question?
Second to that motion.
I second.
Okay,
There's
any more discussion?
She has a question. If it's a payment issue, we might want to hear it and amend the motion really fast.
Okay, Ms. Moore?
Yes. I just wanted to clarify the total. It's about $10,000 due in 90 days. Is that correct?
That's
Yes.
right. Subject to check. Is it?
Yes.
Is that possible, Ms. Moore?
I'll have to make it possible.
And we amend that.
Yeah, okay, we'll amend that. We're giving her a year anyway. Amend it to 180 days, 6 months.
That's 6 months. I make a motion that it's amended to 180 days for the payment.
Oh, I got you. I second that motion.
One more point of clarification. 180 days after the effective date of.
Correct. After the effective date of the order. And I second Commissioner Morse Jarman's motion to modify the prior motion so that it is 180 days.
Okay, any more discussion? Okay, all those in favor, please say aye.
Aye.
Aye. Any opposed? Okay.
Thank you, Ms. Moore.
Thank you.
Do you want? I think we have. Okay, so that brings us to item 5D on the agenda. Enred versus Robindale Tamara's Homeowners Association, case number 2025-612. Do we have anyone present for the respondent? Oh. Is Stoneman here? Did you raise your hand, sir? Oh, okay, come on out.
Yeah, we can just come up and have a seat over there.
Well, yeah, this is Mr. Chavez. He's yeah, Bill Pepper, Deputy Attorney General for the division. This is Mr. Chavez. He is the filed the intervention affidavit. He's not one of the respondents.
Got you. Gina Hedarian, for the record, is your intention to ask any questions of Mr. Chavez? Or can we excuse him?
I was not intending to, because since neither of the served board members appeared, we were just going to proceed by default.
Okay.
But if Mr. Chavez wants to make a comment or statement because he's been part of this process to help where we are and help bring this case, certainly he can make a statement for the record.
Let's do the service issues first, and then if you'd like to swear him in and get anything on the record of his, that's fine, but let's, you want to make any presentation with respect to service and get a finding list on the default side?
Can we do appearances first, just to make sure?
Yes. Not here.
Okay. So, Bill Pepper, again, Deputy Attorney General, behalf of the division.
Then can we do, we had someone here, but can we confirm we don't have anyone online appearing on behalf of the respondents?
We sure can. If the respondent or representative are present, please unmute yourself and state your name. Or if you're attending by phone, press *6 and state your name.
Okay.
Yeah, I'm not recognizing anybody here.
Thank you.
Notice front.
Again, behalf of the division. This is a case that involves a very small association, and it has undergone, I'm going to give a little background. Unfortunately, it has gone through some neglect in the last few years. When I say small, I mean it's 7 homes total. However, through the investigation, there were found to be 4 violations. The board lacked 3 board members.
Well, we can do some opening statements. I was wondering if you would give some presentation with respect to service of the, so that we, since we have a default and no one appearing, if you can present some with respect to the fact that they were adequately served for today's hearing. And then
Bill Pepper again, I'm happy to do that.
if she's
down there.
testify.
Okay.
Ms. Gallo, you're still.
Yeah. We can defer. No, you're still good. Okay. Ms. Gallo, please state your name and current job.
Maria Gallo, Commission Coordinator.
And do your job duties include filing complaints for the division?
Yes.
Do your job duties include mailing the complaint notice documents to respond?
Yes.
In this case, did you file the complaint, notice of hearing, and the notice of documents, including divisions exhibits that were base stamped 1 through 23 on February 6th, 2026?
Yes.
And did you send all of these file documents certified mail upon Mike Hilliard and his last known address?
Yes.
Did you send those file documents certified mail upon Scott Keeper's last known address?
Yes.
Also certified, pardon me, also by certified.
Yes.
And could you state those addresses for the record?
Mike Hilliard was sent via certified mail to 7748 Maggie Bell Court, Las Vegas, Nevada, 89123.
And you have proof of the mailings and the status of documents mailed via certified mail?
Yes, Mr. Hilliard's the package was returned to the division, returned to sender as undeliverable, and we received it back on 3/6/26.
How about for Mr. Keeper?
Start with the address, 7755 Maggie Bell Court, Las Vegas, Nevada, 89123, was sent on December February 6th, 2026. It was assigned for, and we received the green card back on 2/13/26, and it was signed by Nora Littner, Littler.
Okay, well, first, the division moves the commission to admit the exhibits that are date stamped 1 through 23 into the record.
So move.
And the division also moves to admit the proof of mailings that Ms. Gallo testified to.
So move.
Division also moves the commission to find that division has proved sufficient service of notice to the respondents through service of the directors, I should say respondent singular. Through service of the directors as shown in the most recent filing with the division in this case.
So we need a motion?
Yeah.
Okay.
But I mean,
Oh, okay. I will move to accept that. Do I have a second?
Second.
All those in favor, please say aye.
Aye.
Okay. Also, the division is proceeding under NAC 645.860, failure of the party. Pardon?
16.
Oh,
Apologies.
yeah, that's from the, yeah, I'm sorry.
I didn't know what the template for.
Thank you.
Sorry.
With the relevant NRS 116 statute, failure of the party to appear at the hearing. And the complaint is part of the record since it's been filed. Because the respondent has failed to appear and defend, the commission can accept the factual allegations as well as stated legal violations in the division's filed complaint as true. The division is seeking.
So the action would like to.
Yeah, as a remedy, the division is seeking costs of.
Oh,
No, yeah. Okay.
Just ask to determine whether.
June Haydaring for the record, would you mind reading the allegations to the record?
Yes, no pepper here. I'll go through and I'll read all the factual allegations. First, the respondent association, entity number C12712-2001. It consists of 7 single-family home units in a common interest community located in Las Vegas, Nevada. Number 2, on May 13th, 2025, the respondent association filed a registration filing addendum naming Mike Hilliard as board president and Scott Keeper as board secretary. Mike Hilliard was elected or otherwise appointed to a position on the board of directors for the respondent association and on information and belief as to the date of the complaints filing continues to hold that position. Scott Keeper was elected or otherwise appointed to a position on the board of directors for the respondent association and on information and belief as of the date of the complaints filing continues to hold that position. Outside of Mike Hilliard and Scott Keeper, the respondent association has no other current board members. On August 12th, 2025, Division's Office of the Ombudsman received an intervention affidavit filed by complainant, a unit owner and former board member, Jacob Chavez, alleging that the respondent association had committed various violations of NRS 116, including that they had not held any board meetings in the last 5 years, did not inform unit owners of the association's financial status, did not collect HOA dues from all unit owners, and failed to maintain common elements of the association. On August 19th, 2025, the division issued letters by certified mail addressed to the record owners of each of the 7 lots within the respondent association as exemplified by copies sent to complainant Chavez and to unit owners Richard and Jean Rayner based on ownership records as shown by the then
Clark County real estate records, and those were exhibited, those letters. The owner of 7728 Maggie Bell Court, complainant acknowledged receipt of the notice letter. The owners of 7725 Maggie Bell Court received the notice letter on September 5th, 2025. No response was made to the division. The owners of 7735 Maggie Bell Court received the notice letter on September 5th, 2025. No response was made to the division. The owners of 7738 Maggie Bell Court received the notice letter on August 23rd, 2025, and no response has been made to the division. Notice letter addressed 7745 Maggie Bell Court was returned by the Postal Service with the notation that the address was vacant, unable to forward. The notice letter addressed 7748 Maggie Bell Court was noted by the Postal Service as moving through network. The record owner is shown in the Clark County Assessor's Office as East Exit Home Solutions LLC for the registered address of 4030 Wake Forest Road, Raleigh, North Carolina, 27809. The owners of 7755 Maggie Bell Court received the notice letter on September 5th, 2025. On September 11th, 2025, Catherine Null, Ombudsman's Office Program Director, referred the matter to the compliance section for further review and investigation of the apparent violations of NRS 116. On October 27th, 2025, after further investigation, the division sent Respondent Association an NRS 233B letter notifying the Respondent Association that the division has obtained sufficient evidence referencing alleged violations of NRS 116.31034, NRS 116.31083, NRS 116.3115, and NRS 116.3107, and NRS 116.31152, to commence disciplinary action by filing a complaint as a result of the investigation. Those are the factual.
Okay.
Yeah.
Thank you.
Well, the violations of law.
All right, just clarify, you want to hear the violations.
The violation. Yeah. Ask it. Would you, yeah. Bill Pepper. For the division, would you like to hear the violations?
Yes.
Okay, first, the Respondent Association violated NRS 116.31034, by failing to maintain at least 3 board members. Next, Respondent Association violated NRS 116.31083, by failing to hold board meetings at least once each quarter. Next, Respondent Association violated NRS 116.3115 by failing to assess dues against all units. And then finally, Respondent Association violated NRS 116.3107, failing to provide for the necessary maintenance and repair of common elements.
Okay, thank you. Before we move that the factual allegations of law have been proven, I would like to give Mr. Chavez an opportunity to make a statement. Can you please raise your right hand so I can swear you in? Thank you. Do you solemnly swear or affirm that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth?
I do.
Okay. Anything you would like to add to what you've heard today before we make our decision?
Well, I've been kind of investigating myself for the past couple of years when I found out that the people were more or less, I started talking to the neighbors. I said, have you paid your dues? They said, no. And then some said, well, we're on self-pay. We go to the bank and pay. And I ran it for about 20 years before. And they used to hand deliver the checks once a year because it's very little, $220 a year. But I got sick about 5 years ago and had to turn it over to this guy, Richard. And he never kept up with it. Nobody in our
HOA is interested in HOA. I'm the only one. So now it's going to, when it rains, it looks like alfalfa fields in the houses across the street from the weeds. But besides that, we don't know how much money's in the bank. And I don't know what to do. I've called, I think you've seen a letter. Did you make a copy of it? I try to have an election in December, but nobody answered. So nobody responds. So I don't know what to do. That's what I leave it up to you.
Thank you very much. Thank you.
So I believe this is opportunities for commissioners to ask any questions.
Yes.
You can ask any questions and then eventually make a finding whether or not you find facts and violations. And then you can move on to discipline after.
Commissioner Haydarian, I just want to confirm the division sent letters to each unit in this community with zero response. Like nothing came back. Is that correct?
I should probably defer that a little bit, but my recollection is that a couple people, I think, called, I believe, the division, and but it more or less ended there.
But the attempt was there.
Yes.
To contact every unit owner within the association.
One other thing, I still.
Sure.
About 15 years ago, when the neighbors told me that they wanted to do away with the HOA, I checked with the ombudsman here, and they checked on it. And they said we couldn't dissolve the HOA because the street is too narrow, so the city wouldn't take over. So I told them I couldn't do it. So they still don't want an HOA.
Thank you. Commissioners?
Commissioner Tibbetts, what did this, when we reached out to the unit owners, what did the letter say?
The letter that went out to the owners came from, said that the letter is informing you that the real estate division has received, that's the wrong letter here. Yeah, is it in? Could be in our exhibits here.
Commissioner Haydarian, for the record, I think it's base stamp number 13 is one of them.
Yes, 13. Yes, that's an example. So attached were some of the examples that were sent out by Catherine.
Commissioner Gilliam, were any of the board members at the time the letter was sent, were they the respondents or?
Bill Pepper, the board members at the time, according to the last record that had been filed, which is number 3, base stamp number 3, were shown as Mike Hilliard and Scott Keeper. And Mike Hilliard, my understanding is that everything that has been sent to him has come back undelivered or something to that effect. Scott Keeper did contact us, and we thought maybe he would speak up and possibly file something, and it could be that he just, I know he had indicated that there were some family medical issues. And that might have been a factor because he seemed to be interested to somehow be involved, but nothing happened and we received
it. Commissioner Washington, question. Mr. Chavez, are all homes occupied?
The one, 2 homes are investor owned.
So they're out of
And
state
that
owned.
Mike Hilliard, he's in Canada.
Hmm.
And And they've been doing a lot of Airbnbs. They've got thousands and thousands of dollars. I happened to bump into the code enforcement officer one day when I went to a mailbox, and he was there and told me that they owed about over $20,000 in fines. So he sold one house. I met the new owner last 2 weeks ago. He seems to be cleaning up the house, but the one house he hasn't been able to sell. But they were doing party homes and Airbnbs. That's why he doesn't answer no, because he's in Canada. He doesn't care.
So follow-up question. So in terms of being able to get adequate number of board members, that's probably an impossibility because all the owners are out of state.
And the ones that live there don't want nothing, don't want an HOA. Yeah, there's only two of us, the original owners. The rest of the homes have been sold 2 or 3 times. And I'm the original.
I don't know what the answer to that is.
Any other questions? Okay, so at this point, I would ask for a motion to find the factual allegations of law have been proven.
Second.
Oh, okay,
Oh, sorry, you're not done yet.
That's okay. Let me.
You
So
went,
in
I
the
went too
case
fast.
NRED versus Robindale Tamara's Homeowners Association, case number 2025-612, I would move that factual allegations have been proven. All at 1 through 4. Is that correct? There's 4 there. They've been proven. Do I have a second? Any discussion?
Is it factual allegations 1 through 16? Right, and the violations of laws?
Oh, you're right. That's why I asked. 1 through 16 have been proven. Thank you. Commissioner Jarman, can you second my amended?
I second your amendment.
Thank you. Okay, all in favor, please say aye.
Aye.
Aye. Okay, that motion carried. Okay, Mr. Pepper, do you have a recommendation for discipline?
Oh, that was part of this. Almost. It was tax and violations, right? Or did I hear it wrong? The motion?
I think I still. Okay, then in the case of NRED versus Robindale Tamara's Homeowners Association, case number 2025-612, I also move that the violations of law have been proven, number 1 through 4.
Well, second.
Any discussion? Okay, all those in favor, please say aye.
Right.
That's been carried. Now, please, a recommendation.
Bill Pepper, again, for the division. Division is seeking 1,000 in costs, no attorney's fees, and 6 hours of education for board members to be completed within 6 months. Yeah, to clarify, no administrative fines.
Oh, no fines. Okay, so I'm sorry, Commissioner Hayter for the record, so no fines or fees and costs.
Fees and costs, maybe.
Yeah. No administrative fine, $1,000 for costs and no attorney fees. So total 1,000
Plus the 6 hours.
plus.
Commissioner Tibbetts, is this just kicking the can down the road because they're not responding? We're just gonna be hearing this back in 6 months?
We don't have a duly elected board now, so what
Commissioner Haydarian, this sounds like a defunct. I see in here that there's the option for application to a court of competent jurisdiction for appointment of a receiver. I mean, is that where we are? with this. Otherwise, Commissioner, doesn't really resolve anything.
First kicking.
You're right, yeah, you're absolutely right.
Not really sure what that entails. Maybe someone can explain that process.
Pardon me, Bill Pepper, again for the division. I'd like to add something to the record. Mr. Chavez informed me here today earlier that one of the neighbors, I believe it was Mr. Keeper, had actually prepared a ballot form. So there were some steps taken here to try to accomplish creating a board moving forward.
The ballot's not good because it's not written correctly, but
Commissioner could get the record. I mean, they
Yes.
select a proper board and it's not.
Give them a chance, 6 months, and come back in 6 months and see
Yeah.
if they, yeah.
If they can elect a board in 6 months, otherwise you move procedure.
Well, we would determine that, I guess.
Is it in receivership?
No. Because this is just the tip of the iceberg here.
Right.
There's so much more. There's no one's paying assessments. There's no financials. There's
No,
no.
nothing. This is a mess.
This
It
is like
says there's a
step-
reserve study, but I
Step
don't know.
one is, I mean, they're selling units with probably without resale
Oh, yeah.
disclosures. So I guess the first thing would be to install a board. I mean, would the Commissioner here, Darren, in the interim, can we work towards getting 3 and maybe start with 2? And then keep trying to work to get 3 at least and come back for a status check and then keep us posted.
Commissioner Gilliam, I agree with that. I would recommend that we see them at the next hearing. Get this moving expeditiously.
So what's the next one would be June, or do you want October?
June, yeah.
Commissioner Washington, question, can the resident Mike Hilbrand, who lives in Canada, can he be on the board and zoom in?
Yeah.
Then that's, well, if possible, I'm just looking at grasping at straws, trying to find a solution for you guys, but this is the worst situation I ever heard of. So I mean, if you can't get participation with 6 other people.
Commissioner Tibbetts, I mean, I think we should do something to the fact, give them the 3 months to get a board in place, hold the election. There should be some type of fine, the $1,000 fine, just so those that aren't responding realize there's a cost associated to this. So they've, I mean, $1,000, like maybe that gets them motivated to move forward.
Point of clarification, more Starman, is the fine going to be assessed to those that don't participate? Not those that are
We
participating?
can only find the
Could be
association.
the association.
Okay, but you have a defunct
Yeah.
association. I don't understand how you can find a defunct association and attempt to get anything.
Commissioner Tibbetts, I'm not feeling hopeful that we will get something. The point being is that they should, I mean, hopefully if they see an order from the division, hey, that you are being fined, your association, that you are a member, you're being fined, there is consequence to that. So it's I mean, I think $1,000 is, there's money associated to it. Maybe get somebody-
Sorry, Commissioner Gilliam, would this notice go to all 7 homeowners of the association?
Commissioner here, Darren, I was gonna
Since
say
they're not
that
board
too.
members?
Once that is signed, it maybe needs to go to all 7
homes.
homeowners
Yeah.
of record. Asking for people to step up.
Participation, notifying them of the fine, whatever.
Commissioner Morris Jarman, I would like to stipulate that that letter be strongly worded that they will be fined with escalating fines for lack of participation, because they gotta respond.
I
They
agree
just
with
can't continue to ignore what's going on.
I agree.
So
Commissioner
fines
Gilliam.
Become accumulative.
Could we also mention the potential need for a receiver or receivership and what that entails if they do in fact have to go into receivership? I mean,
You're daring. I mean, it's better to volunteer for the board now instead of losing complete control over the association.
Exactly.
Whether or not they want it. It is not. And that's never, that's not gonna go away. This isn't gonna go away. So, okay.
I agree with,
I'm sorry.
Bill Pepper and division, just a couple other points. The association it has long been revoked. There's more work that needs to get done from the Secretary of State's office. And the NRED fees are of course delinquent and have been long. Not even clear really how long they've been delinquent. Quite some time. Thank you.
Thank you. Commissioner Hadarian, so maybe obtain 3 board members and restore their status with the Secretary of State by the next commission meeting in June. Come back for an update. Then we can go from there.
Second.
Okay, so where are we on our hearing? We've asked for the discipline. We already know they want just 1,000, no fee, no service.
You're meeting a motion
Yeah,
regarding what you want the discipline to. We have facts and violations for your order so far.
Okay.
What you want the rest of the order.
Are we ready for that? Okay.
I'm trying.
Want to do the motion?
Yeah, oh, golly, there's a lot here. Let's see. All right. I make a motion that in the case of case number 2025-612, Robindale Tamaris Homeowners Association, that the disciplinary action is that the association have an election, 3 board members, restore their status with the Secretary of State, and pay the $1,000 in costs in advance of the next hearings, which will be in June.
Could we add the division sends that to all?
Yes, and that the letter goes to all 7 of the homeowners within the association, since there are not any current standing board members. And that the letter also addressed the potential for receivership if they cannot get 3 board members.
And then return first notice.
So at the next hearing in June, yes.
I'm sorry, let me go for the record. They won't be able to get their Secretary of State in order until they make us whole. Am I correct in that assumption?
Bill Super record, I believe that's the case. So they would have to come to current with their door fees, delinquent door fees, however many years it was.
Yeah.
I don't know.
Do we know the last time they paid? I mean, like what's the extent in which we're talking here? It's $425 for 7 doors, so it's not huge annually, but.
Sharice Bates, for the record, so they last paid the division June 13th of 2024.
Oh. So 1 year, so that should be achievable.
So they still, oh, yes, for.
Yeah.
Commissioner Washington, I would like to add that with the resurrection of the board, that they stipulate they must have the meetings at least once a quarter. Preferably once a month, but at minimum once a quarter.
I assumed we'd go through a lot of that once we have that board that can attend the status check in June, right? So that we can address that with that
Get the board
board.
first.
Yeah.
I'll second the motion.
Further discussion? Okay, all in favor, please say aye.
Aye.
Any opposed, say nay. Motion is carried. Thank you. Thank you.
thank you.
Yeah.
Thank you all.
Good
See
luck.
you in June.
Do we want 10 minutes or do we want to get through commission business? That's yes to two questions. 10 minutes?
10 minutes.
Okay, let's take a 10-minute break. We'll be back at 3:25. Thank you.
Is the intense thing wrap up today?
Yeah, here, we're in good shape.
I have to leave at 4.
Okay, excuse me, we're back. Can I get appearances from Carson and Amy?
Carson is ready.
Yeah.
And we are here virtually. Thank you.
Thank you very much. We are going to skip to item 7 really quick, the approval of the, I'm sorry, where are we in the minutes?
6H.
6H, I'm sorry, 6H. Approval of the meeting minutes for December 9th and December 10th, 2025.
I make a motion to approve the minutes of December 9th through 10th, 2025.
For a second?
I'll second.
Okay. Any discussion? Okay, all those in favor, please say aye. Aye. Any opposed, say nay. Okay, that is carried. Thank you. So back to 6A, Administrator's Report.
No. Chairman Spoker, Deputy Administrative Division. Our report today, our technology project is still ongoing. We're still working. We were hoping for ETA completion, but we haven't gotten it yet. So we're anticipating sometime around September of this year. So hopefully that's tentative. We are working on our next biennium budget with our BDRs. We have submitted them. So trying to do some upgrades to the office as far as staffing. We're at about 90% staff level now. We've had some people leave through attrition and some people that just left for higher paying jobs in the state of Las Vegas, so in state of Nevada. So we are still trying. We have we have 4 positions open in licensing. So I think we have a total of probably about 8 positions. Yeah, about 8 positions total open for the division. So we're still working on that to get our staff back up to 100%. We anticipate adding an audit CPA member after doing the legislative session to be able, so we can be able to do audits more frequently and have a CPA on board. So those are just a few things that we're working on right now, and hope to have those completed within the next year or so, or doing the audit probably won't be until after legislative session. And that's it. Questions?
Thank you. Okay, 6B, Licensee and Board Member Discipline Report.
Good afternoon, Sharice Bates, Administration Section Manager for the division. In your packets, you have the most or an updated disciplinary report. It was last updated February 23rd. Just as a reminder, this is just encapsulating any of the orders given by the commission. Anything that has happened since the last commission meeting will be highlighted in yellow. And if it's grayed out, that just shows that they've completed their order discipline. And so those will be removed from subsequent, the next meeting's report. It's pretty steady overall. Unfortunately, we do have, some who have proceeded on to collections or other further debt collection activities, but at least those that have recently been ordered have been making payments. So that's great. So
Thank you.
that's it.
Any questions, Commissioners?
Great, thank you.
Thank you. Okay, item 6C, Ombudsman Summary Report.
Good afternoon, Sonia Merriweather, Ombudsman. I'm going to walk you through 4 of the reports, the Ombudsman Assistance Report, the Homeowner Registration, ADR, and the Auditor's Report. And then the Education Officer will walk you through the Education and Training and the CAM report. So if you look at the first report, Ombudsman Assistant Report, all of these reports are year to date for this year up until January 31st of 2026. There were 139 affidavits that were filed, 80 general inquiries that are walk-ins, emails, phones, and 29 carryovers from 2005. That gave the office an opportunity to assist 237 constituents in complaints that were provided to the division. During this time, 21 cases were referred to compliance, 166 cases concluded, leaving 50 cases remaining. You look to the left of the report, you have the top 3 allegations in for both the South and the North. Moving right along, we'll go over to the Homeowner Association Registration Report. As of January 31st, there were 3,825 associations with 642,718 units in them. 2,946 were what we deem to be regular associations, 115 master associations, 755 sub-associations, and 9 condominium hotels. We're averaging about 5 to 6 new associations a month. Let me change that, a month. And in 2025, it was about the same. So we're bringing on somewhere between 50 to 60, 70 associations each year, new associations each year. That was interesting. It is a lot. I keep saying, where are they going to? I don't know where they're going to, but we continue to get their initial registrations. As you know, they have to file with us before they file with the Secretary of State's office. While some of these communities won't build out in that first year, they have registered with us and incorporated with the Secretary of State's office. If you look at page 4, you're provided with the breakdown of the counties and the types of units in those associations. If we move over to the ADR report, a total of 160 claims have been filed, 136 in the South and 24 in the North. We have 114 in the South and 23 in the North have requested mediation for a total of 137. So far, 81 claims have been assigned to mediation. Twenty-three claimants have requested the referee process. As of this date, only 4 claims have been assigned to the referee. The disposition for the claims, both the North and South, are to the right of the report. And lastly, about 190 applications have been received for subsidy, with 57 being paid, for a total of $24,334 being paid for subsidy. Moving on to the auditor's report, as of January 31st of 2026, 8 audits have been initiated by the auditor. 4 have been referred to compliance for further investigation, and 4 are still under review. I'll be happy to answer any questions that you may have.
Ms. Meriwether, Commissioner Morström, what is the escalation process between the mediation and the referee?
And for the mediation is default currently under the law. The referee process, of course, they differ is the mediation does not have to be an attorney. The referee, you do have to be an attorney. Both parties must agree to participate in referee, or it defaults to mediation.
Thank you.
You're welcome.
Questions? Thank you.
Thank you. You're welcome. Thank you.
Okay, so that brings us to 6D, Education and Information Officer Report.
Go ahead and walk you through this report as well. There are a total of 150 active courses. Sorry, Noel, Education Information Officer. Sorry, I apologize. I guess starting over, we have a total of 150 active courses, 50 newly approved courses. There are 110 renewed courses and 90 current course offerings. In regards to total number of CAMs, we have 743 with a breakdown of 349 as supervising CAMs, 103 as provisional CAMs, 21 as temporary CAMs, and just general CAMs 270. Moving on to the training officer side of the report, total video views are 212 among the 5 videos, and the total number of CIC training section website page views is 4,684. There are been a total of 24 virtual training courses and 2 off-site courses for a total of 214 attendees. Questions?
Thank you.
Thank you. Okay. 6E, CIC Compliance Caseload Report and Summary.
Hello, Terry Weed, Chief Compliance Investigator. I will walk you through our report. If I can bring your attention to the very first page, I think it's page 10. Once again, this report and intervention affidavit, it basically displays how many open case we have at the very top. Currently, we have a total of 45 open cases. On page 11, bring your attention to the very top of this page. It demonstrates that the majority of the cases originates in the South. At the bottom of the page, you'll see that the intervention 2 closed outcome North Las Vegas, North, and then the South. I would like to bring to your attention the very first line where it indicates the number of cases that appear before the commission. In North, there's 1, and in the South, there's 6. Also, I'd like to bring your attention to like the 4th one down where it says letter of instruction. This basically tells how many, what discipline has been issued during this time, during these investigative period. If you see in the North, it's 1, and then in the South, there's been 6 cases that received discipline. Also, there's 10 total CDL compliance demand letters. I know there was some concern earlier about reports regarding discipline. Are we tracking those matters? Well, this is how we track you guys receive. Just to also bring to your attention, previously, I think with maybe last year or so, we had given you, the reports had much more detailed on every allegation filed with the division. We laid it out one by one. At the time, the commission was somewhat concerned that it was too lengthy. It didn't flow well. So at that time, they asked for us to change it. And this is the change, and this is what you have now. But if you're interested in getting that information all over again, I'm pretty sure that we could change the reports again for your consideration for yourself. You're good? Okay. Okay. Then I would like to bring your attention to page 12 for the statement of fact. Once again, it just shows that there are, I think, 36 open cases at this time. Yes. Then page 15, I would like to, I'm sorry, miss 14. 14 basically states statement of demographic. It once again shows that the majority of cases open are in the South. Once again, at the very bottom, it basically tracks discipline. It pending intervention, 3 cases, hearing cases for commission. There's a total of 4. There's a total of 7 letter of instructions that went out, and then there's usually no CDLs for statement of fact case. That basically concludes this report. It's time if you have any questions, I'm available. Okay, I'll take my leave.
Thank you, sir.
talked about also, okay, we did that, right? Okay. 6F, Commissioner Speaking Engagement Requests. So last commission, we discussed an speaking engagement request that I have received from Better Reserve Consultants. And we discussed narrowing the scope of topic. I think she threw out a bunch of different items that could be discussed. So what's being proposed now, the topic and title of a class would, why would an association be brought before the commission as it relates to the reserve study? So what does everyone feel about that topic?
Commissioner Gilliam, it seems to be one of our, biggest issues that we're seeing right now is the funding of the reserves. And the plan, if they are underfunded, what we're looking for is the plan. I guess seems narrow enough that you're the one that's being asked to speak. So how do you feel about it?
Well, I feel like I guess I would work with commission counsel on what as the commission we would want to state and then stick with that. But I think if there's an opportunity from for the public to hear from any of us, I feel like we talked earlier about our reach, right? And I know that Ms. Betterly's classes are very well attended. The number of folks she has on her distribution list, it might be an opportunity for us to make an appearance in the public. So depending on what commission feels.
Good with it.
More strong, I just feel that that's a perfect opportunity to discuss, excuse me, with the organizations, the types of things that you're seeing, as well as the reserve study, which is very important because that seems to keep coming up because it's underfunded most of the time. But all of those things that we're discussing and the areas of concern, that's a good time to disseminate that information, types of complaints, et cetera.
So what do we need?
Well, this isn't, this one wasn't listed. Right?
No, it
Action item.
is 6F.
Yeah. So it's not listed as an action item generally. So there won't be any action. Although I think in the past, at the last meeting, they talked about you speaking and it seems like everybody's comfortable with you speaking as to your experiences and what you've seen and what often comes before. And I think you can do that without an action of being, usually to the extent that you are going to be speaking on behalf of the whole and communicating views and saying, here I am as a representative of everybody.
That's what they're asking. That's what they're asking.
The body, but we don't, but we can't take action a moment on this. That being said, I think you're still cleared to go speak at this and speak to your experiences as a commissioner and what you see coming before the commission in these areas, the reasons you see these things come before. And if you want to get from any of the commission staff, whether it's some list of like, this is what we see the most common reasons since they're the ones prosecuting them. But I think you can still do that.
Okay.
More strong.
You might want to make it.
It's also a good opportunity to talk about continuing education. The importance of continuing education, whether you've already accomplished your CTEs or whatever, but you need to keep abreast of that.
Okay. Okay, so we're all on the same page with that. Okay, great, thank you. Okay, so the next item is 6G, State of Nevada Controller's Office debt collection process for fines issued by the commission.
Yes, Commissioner Morse-Jarman, I sent an inquiry out. I have not received a response back. I will follow up again. I don't know what the deal is going on with the controller's office. I'm going to contact Cisco and see if I can get a handle on it there. I don't know. This is not forthcoming with information, so I will continue to press on.
Commissioner Herdarian, is this something we want to keep on our agenda?
I think so. It'd be nice to know, what they're doing in terms of fines, and we're assessing these fines. Are they collecting anything? Or is it a waste of time?
Right? Thank you. Okay, we've approved the minutes. So item 7, discussion and decision, date, time, place, and agenda items for upcoming meetings. So are we still on calendar for June 9th? June 9th, 10th?
11th. Yes.
Okay.
And the commissioners will be in Las Vegas.
Okay. Thank you very much. Okay, there's no further business. We will move to public comment. So members of the public are encouraged to address the commission regarding any matter. However, no action may be taken on a matter that is not listed on the agenda. Comments may not be made regarding matters that are or may become the subject of a formal complaint before the commission. Comment may not be limited based on viewpoint. Individuals who desire to submit written testimony should submit it to the commission coordinator. If you're participating by phone and wish to provide public comment, press *5 to raise your hand. Hosting staff will recognize you when it is your turn to speak. You may also press *6 to unmute yourself and state your name. If you're attending by video, click on the raise hand emoji to indicate that you'd like to give public comment. Hosting staff will recognize you, or you can unmute yourself and state your name. Public comment may be limited to 3 minutes per person at the discretion of the chairperson. We'll start here. Is there any public comment in the room? Nope, not recognizing. Up to Carson City. Any public comment?
There are no members of the public here in Carson City.
Okay, thank you very much. And virtually, do we have any public comment?
I do see a hand raised by Mike Kozar. Go ahead, Mike.
Yes, good afternoon, commissioners. Been a long day, so I'll make this pretty quick. First of all, you review these ADR information that you get every quarter. Let me give you what I see when I read that just briefly. When I look at this ADR, you had 137 ADR attempts, of which 23 were successful. That means 16% of the people that come to mediation actually succeed as been measured by the Nevada Real Estate Division. But success in their mind is an agreement is reached. I'll remind you that the intent of ADR is to defer litigation, to prevent litigation. That's why legislators put it in place. So unless we know how many of those ADRs ultimately resulted in litigation, we really can't count that as successful. Okay? And my point being is that 16%, if that's the success rate of mediation, I think that's a pretty poor success rate. The other thing I'd like to point out is that mediation is a default. Anyone can veto it. So if any party, particularly a deep pocket party that has the resources and wants to go to litigation to preclude further action, they can do so by rejecting all other options and go on to mediation, go through perfunctory steps, and then simply move on to litigation, which then puts the other homeowner, in most cases, in a situation where they're risking a lot of resources for what real benefit. So that's why the legislators put this together, and I don't think we're actually accomplishing anything. At least through the referee program, the homeowner walks away with some type of determination other than from the association itself. And yet you can see the participation rate there was almost nothing. The other point that I'll make, and has to do with the workshop. We just went through this great workshop, and I appreciate the time and attention you put onto it. However, what's next? I never heard the commission decide what they're going to do next in the workshop. Is there going to be another workshop? How many of those items are coming back for further workshop? It's just not clear to me. Technically, according to the statute as I read it, once you complete a workshop, you can move forward with whatever you determine as a commission to make it a regulation. You have to hold no further workshops, no other commitments. So from a public's perspective, they don't know where you stand. Of those items, 15 items we had today, how many did you approve and move forward, and how many do you want to come back? I never heard any votes, any other determinations at all. So I'm frankly confused as to what's next. Thank you very much for your time. Most of those are administrative things, which is what I'm trying to talk about when I talked about Section 5. What are the rules? How does this going to operate? You have a slightly different environment than most regulators. Most regulators, the regulator themselves determine, and then they open a workshop for the homeowner, for members to then comment on. This particular regulator has you all they have to convince. And then you all make the decision as a commission. Then it moves on to homeowner communication. And so that's why it's somewhat confusing and not the typical APA process that you would normally deal with under NRS 233B. Thank you very much for your time.
Okay. Is there any other virtual public comment?
And if there is anyone else who wants to give public comment at this time, click the raise hand emoji or press *6 on your phone. And I am not recognizing anybody else who's wanting to make public comment at this time.
That being said, I'll move to adjourn. Do I have a second?
Amen.
All in favor, please say aye.
Aye.
We're adjourned. Good job. Tomorrow.